Good morning, Patricia. Judge is coming in now.
All right. Good morning.
Good morning.
Good morning, Patricia.
Good morning. How are you?
Good, how are you?
Good.
Good morning, ladies. Thanks for squeezing this file in today. Let me
Good.
have appearances for the People versus Lewis, please.
Good morning, Your Honor. Patricia Madernack for the People, P84088.
Good morning, Judge. Attorney Rita Soka on behalf of Mr. Lewis, P86239.
All right, so I'm assuming everybody's seen the latest report, which I think is the one I'm looking at, dated November 17th, that said Mr. Lewis is not competent.
Yes,
Correct.
Judge.
All right, so what are we going to do?
I believe that this case has to be dismissed.
I agree.
All right, is that a no process from the prosecutor's office then?
Yes, Judge.
Hearing no objection, dismissed.
Thank you, Judge.
Thank you, ladies.
Thank you. Have a good day.
You as well. Heather, make sure you give Mr. or Officer Crova his props today.
His the stamping capability.
He already did it.
Hang on here, I'll let her know you want to talk to her. Okay. Hey, Ronald. Are these altars Oakley?
No, it has the
Oh, the letter.
G and M.
Okay, so yeah, we can do 4-3 then. I got my doctor sheet today, so.
Which? Which time you want? Oh, 403, what?
Right.
That's what mark. The defendant's here, correct?
Yep. No resolution. You know, granted, I will say this, so it is an accident, you have to check with the other side, make sure they're not on a deductible or anything like that, so I get that. But most times that's the same route.
I just remember but I remember when Jane, it was in state. Unless they. It was hard. No. Double part.
Rena's not enough.
Yeah. Well, so is she gone, or
I think
is
she's now with the prosecutor's office, I heard she wants to do an NBC with. And she asked me about that before, which. So. I can't say what happened, or she wasn't feeling the prosecutor.
now? Do you remember Peter Kowinski?
All the others. Yeah, I remember.
I ran into him recently. And he was with his wife. And they were perfect. She was more happy. As I thought, you want this and this, and they are in the store. You know, like they're always like, they always do things. This thing.
Yes.
So that's when they went every time.
Yeah.
And
More than the same thing.
yeah, the bartender knew exactly what they wanted. And, you know, he got a water, she got a blue moon or something, and, we were talking, and she said, we got her out now, because the grants on from the county. So if he really wants to come back, I don't want to, I want to ask him, I'm thinking, because in his mind, he can't, you know, knowing that your woman is in wrong, he would not have been defending herself.
Yeah, I get that.
And so he said that he was trying to finally wash him off. They had a position,
Okay.
but he's really hoping that Wayne County gets the grant back.
They were not so many people were taking it. Well, that's the other part.
Yeah.
Yeah, unfortunately, it is time. Whether you're a prosecutor or a defense.
Yep.
When you have that.
Exactly, and
routine.
Yeah, and so but he said that he.
I didn't know he was on, I kind of feel bad how they, sort of.
Thanks.
He would have, he needs,
All right, wait.
he needs to be one of those lawyers who sits in their office and does paperwork all day.
Yes, yes,
And to be prosecuted,
right, because they still put you out in the field.
as soon as you start, they throw you into the fire, they hear you go.
They want you to open the doors like a waiver.
Okay, thank you, I'm going to do some more fire.
So you know, kind of like the days or whatever, like, this is our last. And then rest for next door.
Yeah, well, every time I come in here for a
Oh, okay.
that'll make it easier, for me. Or you know what I can do, I can just take pictures.
Yeah.
Look at the judge.
And then that way, if you just put it on the sheet, you'll be good to go. Do we have any NDS here? What's his name? Carrie Martin should be here anytime. What case is over?
Jared Anderson.
Is he coming in?
We gotta do a bond amendment, so you want me to call him and get him in?
Well, lead prosecutor can't do it, you can't do it.
I'm unbelievable.
Yes, you are. Very good.
Did you say who was? Yeah, ask him who his attorney is, and then, which is fine, and then just put the attorney and then put him back in the session. Once you find out who his attorney is, which I'm sure that they did, because they. No, just put him in the main session, and, because I don't know, his attorney might have already talked to him, so just name him with his attorney at the time, and then put him in the main session.
He's coming up with his chair.
Who you read, what's your client's name, sir? Your client's name?
Jared Anderson. Oh, you're right. Sorry, what's my good? Did you pull?
It's up there.
Like, and I take
So April 9th.
You're right.
Yeah, he is. No worries.
All right. 34 district court now in session. I don't know if you guys know who's back.
Have a seat. Appearances on the People versus Anderson.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. Jeff Osmond on behalf of Jared Anderson, P45403.
Thank you. I understand we're going to adjourn.
No, Your Honor, this is gonna be a waiver, please.
Okay,
Of exam and then a bond amendment by consent.
all right. Mr. Anderson, have you gone over your rights and options with Mr. Osmond?
Yes, sir.
You understand all those?
Yes, sir.
And you understand the purpose for a preliminary exam?
Yes, sir.
You understand that if you waive the exam, that means your next court date will be down at the circuit court level, not at the district court where you sit right now.
Yes, sir.
Understanding all of that, are you waiving freely and voluntarily?
Yes, sir.
Gentlemen, are you satisfied with the waiver?
Yes, Judge.
Yes, Your Honor, thank you.
All right. As to bond, it looks like we're currently on a $10,000 personal.
Yes, Your Honor. Mr. Anderson has a event. He's a professional heavyweight boxer, and he has a fight scheduled in Corpus Christi, Texas. I have a letter, and I did provide it to Mr. Mohammed about he would need to travel to Corpus Christi, Texas from April 9th and then return on April 15th. And the prosecutor, I don't believe, has any objection to that.
Give me the dates again. Out on 9th.
April 9th out and return April 15th.
No objection from the people, Judge.
All right. So let's do the AOI date, which would be the 27th. That'll be at 9 a.m. So the only bond condition, or the only change we're making is specific travel dates.
Exactly. No.
Okay. All right, so bond will be continued with that exception for travel.
Thank you, Your Honor.
Good luck.
Thank you so much.
Thank you.
Mr. Hudson?
Yeah.
Hey, gentlemen, we got.
I need signatures from you two fellows. Are we gonna get him a notice too? Mohammed, how you been?
I'm sorry, Judge.
How have you been?
Good. How about yourself, Judge?
Much better than I deserve.
We missed you last week.
I missed being here last week.
Thank you so much. Appreciate it. Yes, sir.
How much beef? He's not just a boxer, he's good. He's not just a boxer, he's good. What's his name? Just try not to fast car. That sounds stupid though. Take the speeding ticket. Speeding ticket. Especially here. Play it up. Somebody give you a break. Yeah, probably. All right, let me know.
You guys talk to an attorney?
Yeah, he's talking to the prosecutor.
Okay. Is it okay to sit? I'm sure he's sitting outside.
Good morning, Mr. Washington.
Yes, good morning. I
Uh-huh.
think I have Billy Reed.
Yep, he's on.
Oh, okay.
Did you need to speak to the prosecutor or did you need to speak to Mr. Reed?
Let me speak to Mr. Reed first, and then after that, I'll speak to the prosecutor.
All right.
Thank you.
You're welcome. Mr. Washington, did you need to speak to Mohammed now?
Yes.
All right, let me put you in there.
Okay.
Johnson.
They're ready to set exam. All right, we got a prosecutor though. That's what I'm going to get on. Right. I don't know if it's stuck.
What's the name? This is Eric Johnson. What Wednesday looks good? Or, oh, I'm sorry, you're setting for exam,
Yeah,
April 17th or April 24th?
April 17th. What time are we looking at?
On which day?
On the 17th.
1:30, or 2?
What would you prefer? 1:30 or 2 o'clock on the 17th? 1:30.
1:30?
1:30, please.
All right.
So the next date will be in person here again at one. That's the Independence Day. When you come for that hearing.
Okay, John Johnson? Yeah. So you have to be back here in this court, in front of this judge in this courtroom on Wednesday, for April 17th at 1:00, okay? Good luck, everybody. You got that?
Thank you. No, okay.
No, we got it?
No. All right. Thank you. And then you come for the next meeting because it'll be a testimonial. Such a mini trial. And you are. Or let me know and I can bring you about that.
And this, sorry, you have a ticket that needs to be paid or put on a payment plan?
I'm gonna address it on the way out.
Oh, okay, perfect, thank you.
Thank you.
Do we need to stick around for judge?
No, you're all set.
All right, thank you so much. I'll see you at 11:30.
All righty.
Okay, we're just looking for an exam date on this. Correct?
All right. I will get that for you.
Thank you.
You're welcome.
What date's good for you, either the 17th or the 24th
Of April.
of April?
Yeah, I have another exam with, Judge Green on the 17th. Is that Judge Oakley on April 17th? Okay.
Who is that exam, or you don't know?
I do have the name of that exam on April 17th.
Who is it?
Brandon Lazaire, LAC.
It's us.
It is you.
Yep, it is us. And we have that at 11:30.
That's right. I just
And you
check
have
it
a
out.
12:30 with Raphael Ilion.
Not mine.
It's, I think Mr. Gozi stood in for you that day, the same day that he stood in for you, unless he took it from you.
That case might be his, but I'll look into it. The name is Raphael Ilion.
Yeah, Ilion. So on the 7th, do you want 1 o'clock?
We'll do 1 o'clock.
All right, let me put your notice.
Hey, Joe. Mo said he's waiting on citations for Delta Freight.
Yeah, this one we need to run the records, so just not issue. Same day.
Are we ready on, these two more?
Yes.
Okay. So they,
All right, the report did report now in session, I'm going to open presiding.
Well, they want it on the record.
Have a seat, folks. All right, are we ready on Jason Shepherd?
Yes, Your Honor.
Fellas, your appearances?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Thank you.
Good morning, Your Honor. Daniel Butera on behalf of Mr. Shepherd.
All right, and we're going to adjourn for a final with the complainant to be present.
That's correct, Judge, April 3rd at 9:30 if possible.
Unless Heather tells me no real quick. 9:30 will work.
And we need to address a bond issue if possible, Judge.
All right, let's see what we got for bond now. Make sure we're on the same page. I've got a $10,000 personal bond,
Correct.
standard conditions, and not to harass, intimidate, molest, etc. Rosemary Appleyard.
Okay, so there is no issue with him having contact, Judge,
I don't
correct?
see a no contact.
That's what he thought. When he was arraigned in front of you, he explained to you that he's her caregiver. I looked it up online and I saw no contact with victim. Maybe I saw something I shouldn't.
I didn't do the arraignment just for, so
No.
records
Oh, you
clear, it
did
was
not.
an
Okay.
out county arraignment. But it
Oh,
looks like it's a not to harm, harass, or confront.
Okay, then we're set, Judge, not an issue.
Okay, so bond will continue.
Thank you, Judge. All right, you're all set.
Have a good one, fellas.
Let me give you a note.
Oh, we're gonna get the notice. Have a seat, Mr. Shepherd.
What else is right?
I think that's it.
Oh, I thought you said you had two, Freddie.
The other one was adjourned.
It's a shocker.
I'll have another one for you shortly, which is another bond issue.
Thank you.
Just so that you're aware of
What files that?
Christopher Stewart.
Stewart?
Yeah.
Thank you.
What in the world's going on? We can't get some flow going.
No, I don't know.
Miss 9:30. This was a good sized document.
Yes, Mr. Washington, he's on Zoom if he's ready on read.
Reed. Mr. Washington, are you ready on Reed?
Yes, Your Honor.
Awesome. Your appearance, please.
Yes, good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Billy Ray Reed. Mr. Reed, if you can state.
Mr. Reed, activate your camera if you've got one, please. There you go. Thank you. Mr. Reed, can you hear us okay? Thank you. Go ahead, Mr. Washington.
Judge, I just received a discovery on this, so I'm requesting a preliminary examination date.
April 17th available for you?
You only have 2 o'clock left, unless you want to look at tomorrow.
Yeah, that looks like a good date.
That is a good day?
Yes.
All right, let's do 1 o'clock.
Okay.
Mr. Reed, that works?
Yes, Your Honor.
I will continue your bond.
Thank you very much, Your Honor.
Thank you.
Yeah, have a good day.
You ready on Stewart?
Yes, sir.
Yes, Judge.
Appearances.
Good morning, Your Honor. Patricia Internet for the people, P840.
Daniel Butera on behalf of Mr. Stewart, Your Honor. Mr. Stewart, come on up. Judge,
And
we're
what are we
asking,
doing?
final pretrial on April 3rd. Complainant must appear. And then we would like to address a bond issue.
I don't think he's got a bond.
If he hasn't, Judge, it might have been an out of custody arraignment,
So I'll do
so.
that 9:32.
Yeah, same time.
Yeah, I don't see where there's ever been an arraignment.
No, today's first hearing.
Yeah, so we can do an arraignment. Would you waive formal reading?
We will, Your Honor.
I'll enter a not guilty plea.
Thank you, Judge.
Let me see if there's a bond rec in the file, gentlemen.
Let me call you right. Yeah.
Doesn't appear that there is. Do the people have any bond? Oh, here we go. Police Department requests a cash bond. Prior police runs, prior incidents with same complainant. Requesting 5,000, 10%. And that's all they're requesting. Ms. Mandernack, anything to add?
Your Honor, I have no objection to the 5,000, 10%.
Your turn, counsel.
Judge will ask for a personal bond. There was a divorce that was going on. That divorce has now been settled. They're no longer living together. He's living in Monroe. There is a custody order in place, Judge. He came here to court voluntarily today. Not voluntarily, he was ordered to come to court, but he showed up here today, Judge. So I don't believe he's any type of flight risk. We're asking you to give him a personal bond.
All right. Did you say divorce is final?
Yes, divorce is
All
final.
right, so I'm just gonna order, and there's no,
And there's already a PPO in effect too, Judge, so he can't have any contact. This incident was back in April of last year.
I'm just gonna make a note not to harm, harass, or confirm.
Well, one other thing we are requesting, Judge, again, there is that custody order in place. The only thing he would like permission to do is to discuss the care of their children, and they actually have an app that they use.
Not to harm, harass, or
Okay.
confront. So that doesn't say no contact. That just means no threats, no harassment, et cetera, et cetera.
There you go. Yes, sir.
I'm sorry, Mr. Bahar, could you please put the case number for the custody, for the divorce on the record if you have it?
I don't have.
Okay, never mind.
All right, so I'm gonna put you on a personal bond, sir. First condition is the obvious one, stay out of trouble. Second condition is almost as obvious, be here in court for April 3rd. Third condition, not to harass, harm, or confront the complainant. Understood?
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess that up?
Yeah, yes.
You just give me an IOU. All right, anything else, gentlemen?
No, Your Honor, thank you.
Yeah, have a good day.
Thank you, sir.
You're
You're
welcome,
welcome.
sir.
They're going to give you a notice, okay?
Are we ready on Evans?
Yes, Your Honor.
Appearances, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
And good morning, Your Honor. Attorney Michael Kelly, P77187. On behalf of Ms. Evans, who's present, approaching to my left.
Good morning. What are we doing today, counsel?
Your Honor, today's date and time set for pretrial in this matter. I did just receive the completed digital discovery this morning at 9:12 a.m. Obviously, I need a little bit extra time to review this with my client. So I'd just be asking for an adjournment, Your Honor.
Pick a Wednesday, any Wednesday.
Any Wednesday, second week of April, we're maybe looking at. Wednesday, April 10th.
Fine. And that's gonna be with Judge Martin, so that'll be on Zoom. How about 9:15?
That works.
All right, bond is continued.
Are you the only one doing in-persons?
I think so.
If we want to do it in person, would it be with you then on another date?
Yeah, I'm back on April 17th and April 24th.
We do the 17th.
No, I'll take when I can get it. Let's stick with the same time then, just a week
9:30.
later. 17th and 9:15.
All right, thank you, Judge.
And then we'll get you a paper notice.
Oh, I'm sorry, Your Honor, I do have one bond issue to address.
Go ahead.
We would be asking for a civil standby for my client and her son, who both lived at the residence, to be able to regain some property and personal effects.
Yeah, you don't need to change the bond, just set that up with Van Buren Township.
Okay, understood. Thank you, Your Honor.
Thank you, sir.
You're welcome, man. Mr. Coleman, are you ready on anything?
I am, Judge. We have one matter before the court. It's an arraignment pretrial. Dietrich.
And what's the name?
Brandon Dietrich.
All right, appearances.
I think it's our DV prosecutor.
Diedrich, is that yours?
I'm sorry, which case?
Diedrich, Brandon, first name.
It's a DV case, Your Honor.
I am not seeing that on my list today. Yes, that's not my case, so
Okay.
probably not.
Well,
be a part of our STV.
For the record, Your Honor, I acknowledge receipt of the complaint and warrant, waive reading of same and stand mute.
Thank you. I'll enter a not guilty plea for your client. Are
Uh,
you ready for another pretrial date, or you want to talk to the prosecutor and see what you can figure out?
Well, I think we do need to set another pretrial. I'd ask for an in-person pretrial. I noticed that
April 17th.
The 17th?
Correct. My courtroom.
And that's at
9:15.
what time?
9:15.
Thank you, Judge. And that will be both us and the complainant.
I'll make a note of that. We can have the complainant here.
I would ask that the complainant be here so we can settle
that's
some
plenty of time.
matters.
Prosecutor can get that notice out. Let's talk about bond, counsel. Client has not yet been arraigned, so we get to set a bond. The police department's asking for a cash bond with no contact with the victim and no mood altering substances. That's the request from the PD.
He has no drug history, and this is a matter that was alleged to have happened in.
Hold on, counsel. Joe, I can't hear him when you're out there talking. Counsel, start over. I had people talking in the courtroom.
So my client has no history of substance, alcohol abuse. This is a matter that was alleged to have happened in November of 22, and the complaint, the person comes to the court in January. He moved out of the marital home in December of 22 and served her with a notice of divorce. So there's some issues. He's reported he got notice. Once he got notice, he contacted counsel, and we're before the court today. So I'd ask for a personal bond. There's, he has no other history.
Mr. Coleman? If I order no contact, is that going to cause any issues?
Oh, no, none at all.
All right, and there's no reason for Mr. Diedrich to go back to the address on Pine Drive?
No, he's moved out. He stayed out. In fact, I think, so again, I'd ask that they both appear before the court on our next court date, that's April the 17th at 10 o'clock.
9:15.
I'm sorry, Judge, 9:15.
That's all right. All right. Mr. Diedrich, I'm going to put you on a personal bond. The first condition is the obvious one, stay out of trouble. Second condition is obvious as well, be in court on April 17th. Thirdly, have no contact with the complainant, no social media contacts, no phone calls, no letters, don't have your friends talk to her. You run into her at Burger King, you eat at Taco Bell, no contact at all. And do not go back to the Pine Drive address. You understand all those terms, sir?
Yes, Your Honor.
Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on the bond conditions?
I do, yes, Your Honor.
All right. Anything else, Mr. Coleman?
No, sir. Thank you, Judge.
Enjoy your day.
Yes.
See you in person.
Thank you again.
So that's gotta be Manor X, because it's the ex-wife. So.
She said no.
Yeah, she said it wasn't. She said it wasn't on the list. So it's her file. So let her know that she got to notify her complaint. I'm setting it up as a final with the complaint needs to be here.
You said another final?
Mm-hmm. It's a tidal wave. Looks like it's nice out. Where was it looking cloudy?
Yeah, it was like storm over.
Did you have any luck getting mediation set up for a week ago?
Oh, yeah, you've got a mediation Monday and Tuesday.
Oh, great. I love
I just feel like Barney.
it. It's a pretty color. It's pretty Barney-ish. Yeah, would not be flattering. Sure, not a big person. For that color. Oh, this is killing me.
So we don't have to put on the record, we just need a piece of paper.
Actually,
Have a seat back there.
actually, you know what? I just need this to 6. And I don't have time to use it.
The LA prosecutors like that who realize the big picture.
Well, also, I don't have the time. I mean, I get why, because it would just be like set it for final pre-trial, that way it's just like, it doesn't affect on anything.
No, I get it. We have Sequoia Jones, it's going to be a dismissal.
Oh, okay. And we want to go on record, obviously.
Yes, for the dismissal.
Yeah, and that's how I was. Long time. And I
I
always
don't believe
practice.
that, I believe you.
Yeah. Like, we practice defense litigation.
Yeah.
Especially in DV, it's like, okay, is this person. But I only do one type of,
Sure.
you know, a couple types of defense.
He's a very nice guy, but,
Yeah.
you know, he just.
And there are 12 of him, I mean, he's. Oh, and then, did you get? Let me advise you this, just because you know I'm super. I call Sona 136.
She thought that was her lawyer.
Yeah.
She told me in the.
Yeah, somebody didn't say, tell her anything.
So they get, that, does that ever happen to you? They get that notice and they see your name and they start calling that number?
Yeah, and then I have a heart attack and I realize who they are and I spend like 10 minutes. I hang up immediately. I've had a lot of defendants' moms call me.
All right. 34th District Court now in session. I'm Judge Oakley presiding.
Have a seat. Somebody here for Delta? Are you paying the overweight today, sir? $17.90.
Can we make a payment plan?
Go down to the front counter and set something up with the cashier. The misdemeanor is dismissed.
Thank you.
You're welcome. Just for future reference,
Yes,
the
sir.
only reason I'm letting you do this today is because it's a civil infraction, but your company is an LLC. That means you have to have an attorney to appear in court.
Yes, sir.
So if you get a ticket in the future, hire an attorney.
Yes, sir.
You're all set. Go
Thank
downstairs. Mr. Bitar, what do you got?
Sequoia Jones, Your Honor.
I am ready.
Daniel Bitar on behalf of Ms. Jones.
Good morning, Your Honor. Patricia Mandernack with People, T84088.
Go ahead.
Judge, I believe the prosecution is going to nolly pros this case.
That is correct, Your Honor. At this time, the people have moved to dismiss without prejudice because this is a 2022 case, and I cannot contact the complaining witness because their phone number is out of service.
Okay.
No objection.
All right. So Ms. Jones, I'm going to dismiss this without prejudice. We've got a bond on this file, but you owe us money on some other files. So we've got a speeding ticket from 2023 out of Rhinelas. It's got $276 due. You okay with us taking the money that we got on bond on the misdemeanor, paying your ticket off, and then giving you what's left?
Yeah.
Okay.
Yeah, that would.
If you go downstairs, we can make that happen today. You'll walk out of here with some money.
Okay.
Okay?
Okay. Thank you.
Thank you, Judge.
You're welcome.
Going downstairs and straighten it out.
Thank you.
Okay, what is that? That gets down to the cash register. Oh, yeah, sorry. Carrie, how you doing?
Hey, I'm doing good, Judge Oakley. How are you?
Wonderful.
Great. I did want to say something ahead.
Be nice.
You were asking me about case Rafael Ilion, whether I'm on that case. What's going on here? It's Alicia Martin, private counsel, who's on that case.
Thank
You might have
you.
seen
Yeah.
Martin.
Yes, I saw
recently got-
Martin and I thought of you. I'm sorry.
Unfortunately, this town is big enough for multiple warrants.
There's two in the courtroom today.
Two in the house. Two in that house today. I think
At
I
least
was
two.
surrounded by 3 or 4
There could be
the
more.
other day.
Not really that hard.
See if I bring you any fun later today.
I just want some work. I mean, we got this whole docket. What do we have? 8 files moved through here? 10 o'clock in the morning?
Waiting for one,
Moving slow.
waiting for a zoom in from Kalamazoo County Jail.
Well, that was at 10:45, yeah. You didn't have one.
Not me.
Because Anderson. Warren, okay,
Warren.
she's already here.
What the hell's Muhammad doing today? He's only been here once.
He's done all the civil infractions.
Story of my life.
You and me both, Council. Well, then get in here and set some truck plates.
That's good.
Yeah, I mean, I'm okay if you don't want to take your deals, but let's move some files. Yeah, good luck.
Can you let Mohammed know that there's somebody in his Zoom too?
Who did I do now?
Mohammed.
Yep.
Objection was held.
No. So you said something different.
Arthur Wilson, it's a plea. I don't got any defense attorney signature. Mr. Wilson, did you have a defense attorney or no?
No.
Okay.
No.
Is your client gonna be in person?
No, I was given approval that she be via Zoom.
You got approval for Zoom?
Yes, she's an MDOC.
Oh, okay. When she comes on, did you need to speak to her or do you need to speak to the prosecutor?
I need to speak to the prosecutor, and in fact, if there's a way that I can speak with him or her before we call the case and all that, that would be great.
So I'll put you in with him. When she jumps on, do you need to speak to her after?
Yes, please.
Okay,
Okay, thank you.
you're welcome.
I got Wilson Cruz. Yeah, and so I don't need Mohammed for that, do I?
No, not if there's a paper.
Nope, it's signed.
Is it actually?
No, it's
Oh, okay.
Mohammed.
Yep.
And then I do have one for Cedric Jones. We're waiting on Dan.
Is that a plea or a?
I don't know. I don't have paperwork on it.
Oh, okay.
So I gotta go on record no matter what.
It's gonna have to be on the 27th. Make sure.
Yeah, you're out. So this was a final one or? Oh, it's a final pretrial as well.
Final pretrial and then investigator.
Oh, yeah. this one.
Council William,
You are a
William,
Willingham.
William.
I'm giving Mr. Jones his paper.
Thank you. If you only do that, it's part of my very important duty.
Well, that's why I asked you first, or said something first. I didn't want to step on any toes.
I appreciate it.
I could start at Judge Mohammed.
Yeah, two that go on record.
Yep.
All rise. Report back in session. I don't know who's Oakley preside.
Have a seat. Did you already pull the files for the adjournment, Joe?
Yes, sir.
Are we ready on Willingham?
Yes,
Appearances, please.
Good morning, Your Honor. Patricia Meter, for People, P 84088. Good morning, Your Honor. Shava Kirkland on behalf of Mr. Willingham, P 84015.
And what are we doing?
Judge, Mr. Willingham would like to request a bench trial. And Your Honor, people would like to request that this be set for a jury trial.
Really?
You want to do chair? Yes, Judge. And Judge, if this is going to be set for a jury, Mr. Willingham would like to avail himself of the offer.
Okay, what is it?
I believe the offer is a plea under 7694A.
Straight up to the charge?
Yes, to the charge, 1 year of probation, anger management classes, and parenting classes.
Okay.
That is correct.
Understanding that those are recommendations based on what my probation department considered an interview, maybe those will be ordered as probation, maybe they won't.
Yes.
Okay. All right. Anything else from the people?
Your Honor, the other term would be no contact with complaining witness except pursuant to a custody and parenting time order.
For the 12 months? During the 12-month period, that's what you're saying?
Yes, Judge.
All right. Mr. Willingham, have you discussed your rights and options with counsel?
Yes, sir.
You understand those rights and options?
Yes, sir.
All right. And you understand the possible penalty for the charge?
Yes, sir.
All right. Understanding all of this, are you pleading freely and voluntarily? Are you pleading guilty to domestic violence from January 4, 2024?
Volunteer.
Pardon?
Volunteer.
All right. Counsel, would you voir dire for me to get the facts I need?
Yes, Your Honor. My apologies. I should have had this pulled up already.
Incident date is January 4, 24, if that helps you.
Thank you. Mr. Willingham.
Okay, Mr. Willingham, on January 4th, 2024, were you in the area of 10766 Oak Lane, apartment 11205 in Van Buren Township, Michigan?
Yes.
And on that date and time, did you come in contact with Imari Galloway?
Yes.
And on that date and time, did you touch Miss Imari Galloway without her permission?
No.
Okay. Judge, may I have a
Sure.
brief meeting? Thank you.
Arthur Wilson? Come on up, Mr. Wilson. Mr. Wilson, are you going to go forward today without benefit of a court-appointed attorney?
Yes.
All right. Looks like you talked to the prosecutor, and the prosecutor's offered to, yeah. Did you see what he's doing?
No, I didn't.
He's dismissing a drawable license suspended, but that we don't have. All right, so you're going to plead guilty to fail to display a valid license on February 15, 2024, correct?
Yes, sir.
And you understand your rights?
Yes.
Look your rights form over?
I didn't receive that,
Okay,
but I
well,
understand my rights.
Okay, and you understand the possible penalty for the charge?
Well, he didn't explain that to me.
Up to $500 fines plus court costs and up to 90 days in jail.
Right.
You understand that?
Yes, I do.
All right, understanding all of that, are you pleading guilty freely and voluntarily to not having a valid license on February 15, 24?
Yes, sir.
Did you drive a vehicle at a location near Goddard and Middle Belt in the city of Romulus at that
Yes.
time?
Yes, sir.
And was your license valid at that time?
No, it wasn't.
All right. I'll accept your plea. What's the status of your license now, Mr. Wilson?
It has a hold out of Illinois, and I've submitted the out-of-state hearing to.
You got to clear that mess up. Clear that mess up in
Clear
Illinois.
that mess up, and my license is good.
Okay.
It's
All
just,
right.
it's a time thing now. They set up to 3 months.
Okay. I wish you luck. Are you working, sir?
No, I'm retired.
From where?
Progressive Tool, Pico,
Okay.
Southfield,
How long were you with them?
29 years, and then after that, I've still worked another 8-10 years.
Okay.
Still working now and then.
Good for you. All right. Fines that cost $300. That money's due within 5 days. What that means is we got to have it in our hand or we got to have a plan to get it. So if you go downstairs, you can pay it, make a partial payment, or just set up a payment plan.
Okay.
Understood?
Yes, sir. Thank you.
You're welcome. Is Packer the one that Carrie was looking for?
No.
From Kalamazoo?
No, this one is Schlapp. He's stuck in the breakout room with Mohammed.
Thank you. All right, back on the record with Willingham. I can't say it. Willingham. So I think we established time and place. We just need to
Yes.
establish what happened.
Okay, Mr. Willingham, did you make physical contact with Imari Galloway and without her permission?
Yeah.
And is that someone that you have a child in common with?
You satisfied?
I'm satisfied, Your Honor.
People satisfied? So's the court. All right, sir, I'm going to send you downstairs to our probation counter. They're going to set you up to come back for a pre-sentence interview. Based on that interview, they'll put together a report and recommendation. You'll have a chance to go over that with counsel when you come back for sentencing. I'll look at that, and then the three of us will have a conversation before I determine what the terms of sentence should be. Understood?
Yes, sir.
In the meantime, bond will be continued. Counsel, if you go down, you can pick that sentencing date.
Thank you. Thank you, Your Honor. And Your Honor, I believe we requested this at the last hearing, but I don't think anything was ever done after. I'm just requesting a police escort, one-time police escort for him to gather some.
Yeah, you shouldn't have any problem doing that.
Okay.
Right, directly with the PD.
Okay, thank you. Thank you, Your Honor. Have a good
Yeah,
one.
civil standby.
Okay,
Good luck.
thank you.
You're welcome. Parker's got a Van Buren local too. Did you see that? Parker has a misdemeanor from Van Buren. I see it, yeah. 321. Mm-hmm.
Yes. All right.
Hey, when it's convenient, I'd like to go over your no-show list with you. Thanks. Can I have this?
Yep, that one I kept for you.
Thanks.
Is it alpha or is it,
This one's by time, so whatever's easier for them. I've got one of each. I got the alpha and I've got the time one.
It just looks like the actual memory that Terry's waiting for.
Mhm.
Is really actually gonna- just gonna be confident.
That's the one that's in Kalamazoo.
Yeah, because we did have it scheduled for an exam and then Terry got a little better grade. No.
Okay.
Ms. Parker, your attorney is on. He's just in with the prosecutor, so we're just waiting.
Okay, thank you.
And then he'll speak to you when he's done.
All right, thank you, ma'am.
Joe? You know this guy is?
what's your name, sir? Alexander Green.
Thanks, Jeremy. Mr. Green, are you going forward today without benefit of a court-appointed attorney?
As of right now, I cannot afford an attorney as I've been.
That's why the court will appoint one.
I do not appreciate how I was just spoken to in
Okay,
the
so,
conference room. I will be providing.
so my question is, are you going forward today
Yes.
without an
Yes.
attorney? Okay, and Madam Prosecutor, your appearance,
Good morning, Your Honor. Patricia Mandernack for the people, P840888.
what are we doing?
Your Honor, it's my understanding that at this time, defendant wishes to proceed pro se. I very briefly attempted to speak with him in the presence of a deputy. He was unclear as to whether or not he intends to remain pro se for the duration of the proceedings, or if he is just pro se for this
Okay.
hearing. If defendant intends to retain counsel down the line, I would request that this hearing be
Yeah.
adjourned so that defendant. can
Are you
retain
thinking you're gonna hire your own attorney?
Nope.
All right, so you're
I
not
can't
gonna hire an
afford it.
attorney?
Nope.
Okay, so what do you want to do? You want to set
Pro
this to
se,
trial?
I'm fine with pro se. I just want to be,
How do you want to proceed? That's the question.
oh, with a jury trial.
Okay, and you're gonna represent yourself in front of a
Yes, sir.
jury?
Yes, sir.
All right, I will appoint counsel to be here that day to sit second chair. You got any jury trial dates?
Oh, I'm sorry, Mandernack will have to. I can,
Okay, all right, stick around, sir. We'll get you a date.
Thank you.
So Jamie, just to confirm,
Orange is what arrived in the building.
present.
Yes, sir.
Thank you.
April 9th, 20.
Back to Jamie. Thanks.
you said 29? Jury.
Judges, April 29th.
All right, Mr. Green, April 29th, 8:30 in the morning. Understood?
What is this for?
Your jury trial, you just said you wanted a jury trial.
Correct, but there will not be a conference, none of that.
No, that's what today's for.
So today we decided that I'm not.
Today you decided you didn't want to talk to anybody and you asked for a jury trial.
I tried to talk to him and he told me that I'm jumping ahead of myself. Everyone else that
Okay,
was.
sir, listen to me. We're gonna do this my way.
That's fine.
All right, you said you didn't want an attorney.
Right.
The prosecutor said you didn't want to talk to her. I
I'm trying
said,
to
how
talk
do you
to
want
her.
it, sir? Do not interrupt me, sir.
I'm trying to.
Don't interrupt me.
Yeah.
I asked you how you wanted to proceed and you said you wanted a jury trial. I got you a date. Now, do you want to do something other than a jury trial?
Yeah, ask a question.
Go ahead.
Every time I ask for a discovery packet, which is why I told him, I just tried to say the same thing. I'm just gonna tell him that. And you can ask him to come back.
You had a question for me. Ask it.
Right.
I don't need history to hear your question. What's your question for me?
Why is it that when I express my rights and talk to as if they don't exist in this town, not only has Van Buren tried to kick my door in,
Listen,
they have
listen.
never.
Van Buren doesn't work for me.
That's not the.
This is a
problem.
court case.
I understand.
What do you have a question for me about the court case proceeding?
Who would I talk to that doesn't cut me off so that I can get the story out?
What story?
That I'm being literally pushed out of my home because I cry loud.
That's got nothing to do with what's going on here. You're charged with domestic violence.
But
What's
I
in
didn't-
front
I
of
wasn't
me,
told that.
sir, once again, you interrupt me one more time, I will hold you in contempt of court. The first time it's 1 day in jail. Are you clear about that?
I'm fine. I've done
All
more
right.
times.
You're charged with domestic violence. That's what's in front of me. So the only thing that I've got to determine or make sure gets determined is whether or not on March 1, 24 in Van Buren Township, you committed domestic violence. So if there's a jury trial, I'm going to oversee the jury trial and let the jury decide whether or not if that crime was committed on that date. Anything else that you've got going on where your rights are being violated and everything else, that's not in front of me today. If you've got some rights violations you want to proceed with, then you can file charges, you can file lawsuits, you can do whatever you want to do about that. All I've got is a domestic violence misdemeanor. That's the only thing that's going to go in front of a jury on April 29th. Does that answer your question?
Yes, I have one more.
Go ahead.
So what is a normal procedure if I get a defense attorney?
Normal procedure would be you show up for an arraignment pretrial, which was scheduled for today. You would talk to the prosecutor, or if you have an attorney involved, you would talk to your attorney. That attorney would get whatever information he or she thought was necessary at that point in time. They'd probably talk to the prosecutor to see if there was any offer on the table. They might discuss an exchange of information, which is called discovery. Okay. Then they being the attorney, would have some more conversation with you and decide what the next step is.
Okay.
That's how it works. Yeah.
So I watched like 26 YouTube videos before coming here.
Bad idea.
And this, I failed. So
Bad
I'll take
idea.
that L and
Don't watch video. Don't watch that crap on YouTube.
Well, I mean, nobody's answering my. I've called so many times and nobody will. They just
Listen
tell
to
me
me.
wait, and then it
Listen to
gets
me. The attorneys that we have on our pool of attorneys, when we say, here's one of your court-appointed attorneys, they're great attorneys. They've all gotten lots of experience. What they won't do is let you dictate how things happen.
Right.
Okay? But as long as you're willing to play the game as they want to play it, they'll do a great job representing you.
Okay.
You want to start over? You want to hit reset?
Yeah.
Okay. You want to go out and talk to Mr. Bitar again?
Yes, please.
All right. I'm sure he's more than willing to have you.
Thank you. I appreciate it.
All right.
I don't know, maybe they're out of town, I'm not sure, but they're on Zoom.
Mohammed talked to them, I don't know how you.
How could we do this?
Or do you want me to jump in?
Can't make everybody happy all the time.
I know.
I got his file up if you need the actual file.
No, I'm gonna, he's in my office now, he wants to talk to me, so.
Are you able to download it?
No, it won't download.
Not through evidence.com either.
No, I'm looking at the link you sent me earlier. 24.
Dan, I need a little assistance too.
No, it's his name. Green. Oh, there it is.
He doesn't have.
So when I click on the attachment.
I mean, civil infraction.
Okay. And the evidence.com.
Well, because it's a reduction.
Okay, yeah, I have another evidence.com link with it.
And Mr. Dubin, just so you know, is running behind, he has, Conowalski and Reading reading,
Okay.
and, but they said that he is on his way.
I'll email it to her right now.
Heather, could you print out a discovery that, the discovery from Mr. Green, she emails it to you? 'Cause it's not downloading.
Yeah, is it in the file maybe?
I'm sorry.
Green, nice and green file.
Yeah,
I'm sorry, but you said you needed something else.
I got an LLC that's on Zoom from Tennessee. They've made their deal with Muhammad. I just need you to stand there and say you'll represent him to enter a plea. Thanks.
Yeah, send it to me, Patricia, and then I'll.
Mr. McClure.
Okay, 'cause it's-
Yes, sir.
All right, Mr. McClure, you're on for HTC Transport LLC, correct?
Yes, sir.
All right, that's a good news, bad news situation. The bad news is because HTC is an LLC, I cannot let you represent the company in the court of law because you're not an attorney, I assume. Is that correct?
That is correct.
All right. The good news is I've got an attorney standing in my courtroom who is willing to enter an appearance for HTC. Would you like Mr. Bitar to assist you in this matter?
Yes, please.
Daniel Batar on behalf of HTC, Your Honor.
Thank you. All right. Mr. Bitar, I understand that the company is going to enter a plea of responsible to a civil infraction, failed to register motor vehicle, and the failed to register misdemeanor motor carrier violation would be dismissed. Is that correct?
Correct, Your Honor.
And Mr. McClure, that's what the company wants to do today, correct?
Yes, sir.
The misdemeanor is dismissed, fines and costs on the civil infraction, $250. I need you to contact us through our website, Mr. McClure, and either pay that or set up a payment plan within the next 5 days. Can you do that?
Yes, sir.
All right. Any questions, sir?
Not at all.
All right. Have a nice day.
You too.
Patricia, let me know when you send that, because I have to go to my office to.
Okay.
put it.
I just sent it.
Okay, I'll go grab this.
He was on.
She just told me something about Reading. Did you catch that, Joe?
Someone's ready?
Yeah, Heather just told me something about an attorney for Reading, I think. You didn't catch it? No, it's all right. She'll come back.
Oh my gosh.
Hopefully she can know.
I can open the PDF, so hopefully from the attachment.
Not a bad appearance rate today. Okay.
So
And,
the whole thing is it redacted, Tricia, already?
Yes.
in Reading,
Yeah.
you said Dubin's running late,
Yes.
but Reading's not here.
Oh. Okay, and what about Kondamowski? Is he here?
Is that a K?
Yes.
Let me find
There's
him.
another Duke in
Let me find him on the list.
Um,
Yeah, Konowalski, the guys have checked as here.
Okay, and Mr. Duke is on that right as well.
I'm sorry?
Boykins is the last name.
Boykins with a
Yeah, we
B?
retained.
Judge, Jamie has the file.
Oh, okay. Counsel, your appearance for Mr. Boykins.
Deborah Sloso on behalf of the defendant, Mr. Deontay Boykins, who is to my left. Good morning, Your Honor.
Good morning. All right, so you're gonna plead, Mr. Boykins, you're gonna plead to fail to display a valid license on February 8th?
Yes, sir.
All right. Did you discuss your rights with counsel?
Yes.
Understood all those?
Yes.
Understand the options those rights present?
Yes.
And do you understand the possible penalty for the added charge?
Yes.
Understanding all of this, are you pleading guilty freely and voluntarily to the added charge today, sir?
Yes.
All right, did you drive a vehicle on February 8, 2024 near Beach Daily and E-Course?
Yes.
We got only one problem, that's not my jurisdiction.
Oh, it is E-Course, you're right.
No,
All right.
E-Course is mine, but Beach Daily
Oh,
isn't.
Beach
Beach Daily is a mile too far east.
So it's Taylor?
Yeah,
All right, motion to dismiss, Your Honor. For
Granted.
lack of jurisdiction.
Granted.
All right, thank you. Can we wait for an order?
Sure.
All right.
You can present it,
Oh,
an order
okay.
and I'll sign it.
All right, what will be in the register of actions?
Yeah, it'll be in the
All right.
register of actions.
Okay, cool. Is it dismissed with prejudice?
Can't do that with prejudice because we haven't had a witness for you.
All right, okay, thank you.
Thank you.
We'll take it.
Mohammed, talk to me when you can. No, I was expecting to. It said Ron was.
And, for Parker and Slack.
You ready? Are we ready on Parker Council?
We are. Waiver.
Thank you. Your appearance, sir.
Yes, good morning, Brian Schaff on behalf of Ms. Parker, P68271.
All right, Ms. Parker, can you hear me okay?
Yes, I can. Good morning, Your Honor.
Good morning. You've discussed your rights with Mr. Schaff. You understand your rights and the options they give you?
Yes, I have.
Do you understand the purpose for a preliminary exam?
Yes,
You understand that if you waive the exam today, that means your next court date will be at the circuit court level, not at the district court where I'm at right now.
yes, I do.
Understanding all of that, is it your desire to plead or waive the exam today?
Yes, it is, Your Honor.
All right, I'm going to enter a waiver. Arraignment on information date for you is going to be on the 27th at 9 a.m., March 27th.
Okay.
Thank you, Your Honor.
Also, anything as to bond?
No, Your Honor.
All right. And counsel, Ms. Parker's got a misdemeanor charge of retail fraud from Van Buren. I'm going to hook her up with a pretrial date for March 21. She can talk to our court-appointed attorneys then when she's here.
Can I say something?
Yeah, go ahead, Ms. Parker.
I was sentenced in Wayne County back a while ago, and that was one of the charges that I pleaded guilty to my case in Wayne County, and they were supposed to dismiss that retail fraud and another misdemeanor case out of Wayne, the city of Wayne. So that one was supposed to be dismissed.
Okay.
I'm not sure.
Somebody forgot to tell us about it.
Okay, what do I do?
Yeah. Who's your attorney on that case?
Oh, I don't remember. Sorry.
Well, you know what? Let's do it this way. Let's do it this way. How long have you been in custody right now?
I've been here since February 7th, but I've been in jail since February 2nd of 23.
Yeah. So if you want to plead guilty to this retail fraud, I'll give you time served and close the file.
Okay, that'd be great. Thank you so much.
All right. So let's get the
That's so-
facts. On November 21, 21, did you try to take some merchandise from a store in Van Buren without paying for the merchandise?
Yes, Your Honor.
Walmart or Meijer?
Walmart.
I'll accept your guilty plea, 30 days in jail, time served, close file. Good luck with where you're at.
Thank you so much.
Thank you, Your Honor.
You're
Have a good
welcome
day.
so much. You as well, counsel. Better for everybody that way. It was touch and go. It was touch and go for a minute. I give him credit for admitting that he watched 20 YouTube videos. It gave him bad information. We should like snippet that out and save it, right? It's like, look, is this what happened to you?
Yeah.
Still got an awful lot of files.
Don't forget, we have 12, just starting at 11 o'clock.
Oh, yeah. Not much chance of hitting that at the webinar today.
I'm sorry, 12 starting at 10:45.
I got news for you. Next time somebody says something about how small Jeff is, just saying, it hasn't exactly moved fast today without it.
That's true, that's true.
What do you got?
Just a question about Cedric Jones. Did you guys set a date for that final pre-trial? Cedric Jones.
It must have been a while ago.
Printing those out so that in case I forget to start. So Joe, kind of weird. So yesterday, so Cody got a new watch. Yeah. So, it won't vibrate, it won't ring. He went back and he only had it couple days, went in to Verizon or Xfinity and they checked it, it works, everything. Doesn't work. So we go to dinner last night and we're all sitting there and he's like, look, it won't work. So we were messing with it. He has too many tattoos. It won't work under your tat, it won't work on top of tattoos. Judge said it must be because he has too much metal. Because he has like an old fashioned watch tattoo right here, so he always knows what time it is. And it's too much metal in the system, that watch won't work. It won't ring, it won't do nothing, it'll show the time, and he can push the button, but it won't work. Isn't that crazy? So he's like, I can't wear it on my right hand, I'm like, well.
What if he puts it on like underneath?
He's tattooed all, he's got a whole sleeve. Yeah, I mean, not as much underneath, now that you're saying that. Who you here on?
Here on, Kowalski and
Oh.
Reading, she's got a Zoom and she's terrible, but we're waiting the exam.
She's got COVID. So we're waiting for her to come out.
I don't know, I don't know the Zoom number for this.
491-975-6074. Guess
Nine
that.
seven-
975-6074. 491-975-6074. So she's just gonna be a waiver.
And then Kowalski, we're,
They sent in that plea.
yeah, he's just in the hallway.
Oh,
We're
yeah.
ready to go.
Alright.
Grab him?
Yep.
When you get a chance,
Yeah.
can I get a copy of the ticket for the formal hearing, Richard Food?
Yeah.
Yeah.
Happy to reach.
Yeah, just a copy.
Yeah, you just make a copy.
Just so I can refer to it as a formal hearing.
Yeah, because you got the thing that judge denied promotion.
Yeah, yeah.
You can, you can come sit there.
Oh, can you let Carrie Mark know that his, Kalamazoo guy's on? Thank you.
I'll get yourself. He's a plea, and then Reading is gonna be a waiver. On the date, on the question. Driving motor. Yes.
I got, and then Reading's the other one, correct?
Yep, she's on Zoom, Marlies is getting her information right now.
I'm sorry. Yes, yeah, after you take a plea, you're gonna go down there for their. You're gonna come back to be sentenced. That's not gonna take place.
Yeah. No, if you already got her information, that's fine.
All right, so I got Kanalowski, Emery, and Redding, right? Oh, Green also.
Oh, sobriety court? Everyone who's ever done it with me is usually way better off, way better off. So that's good, that's good. Oh, okay. Okay, yeah, it was.
Counsel, who do you have?
I have two, I have Reading and I have Konowalski who's to my left.
I got Konowalski right here.
Come on. And I apologize for being late. I was stuck in
No problem.
saline.
Your appearance for Konowalski.
Stephen Mamet on behalf of the defendant, Your Honor.
All right. All right, so Mr. Konowalski is going to plead to impaired driving, correct?
That's correct.
All right. Sir, did you discuss your rights and options with counsel today?
Yes.
You understand all those rights and options?
Yes.
And you understand the possible penalty for the added charge?
Yes.
Understanding the possible penalty, understanding your rights and options, are you pleading guilty to the added charge freely and voluntarily?
Yes.
Counsel, would you like to voir dire to get me the facts I need? September 22nd, 22 is the incident date?
Yes, can you please state your name for the record?
Timothy Lee Konowalski.
On the date and time in question, did you operate a motor vehicle?
Yes,
Okay, did you prior to operating that motor vehicle, did you consume alcohol?
yes,
And did that impair your ability to drive that vehicle?
yes,
Okay, and would you stipulate for purposes of this plea that your blood alcohol content was higher than a 0.08?
yes.
You satisfied?
Yeah.
I'll dismiss the original charge, accept the plea to the added. Send Mr. Konowalski downstairs to the probation department. Counsel, you can have some input on a sentencing date today.
Sure.
They're going to give you 2 dates down at the counter, sir. One date will be when you come back for an interview with a probation officer. The second date will be your sentencing when counsel will be here again.
And he's been accepted into the sobriety.
He has, great.
Yeah, so
Great.
he's looking forward to it.
Beautiful, beautiful. Glad to have you.
Okay.
Yeah,
But I'll see you downstairs, okay?
Okay.
Just check in with her. I'll see you before I
Okay.
leave,
Thank
okay?
you.
And then,
Are we ready on Reading?
yeah, that's me, and she's on Zoom. She had COVID.
Ms. Redding, go ahead and activate your camera if you've got one and unmute. Counsel, your appearance.
Stephen Mammon on behalf of Miss Redding, Your Honor, who's on Zoom. Your Honor, today's is that date and time set for a probable cause conference. I have had discussions and advised her that she does have a right to have a preliminary examination where the prosecution would have to prove by preponderance evidence that a crime was committed and that she was the one who committed it. She's agreed to waive her exam and have this matter be bound up to the circuit court. Would you like me to voir dire her on that?
In a minute. Hey, guys, I'm getting to the point in my life where I can't filter out, so you guys got to get out of my courtroom. No, that's all right. I don't mind if you're talking, just don't do it in here. Ms. Redding, did you go over your rights with counsel?
Yes, sir.
You understand the rights you have and those options presented by those rights?
Yes, sir.
And you understand the purpose for a preliminary exam?
Yes.
You understand, ma'am, if you waive the exam, your next court date will be downtown at the circuit court level, not at the district court where I'm at. You understand that?
Yes, I understand now, yes.
Understanding all of that, is it your desire to enter a waiver today?
Yes, sir.
And are you doing so freely and voluntarily?
Yes.
Counsel, are you satisfied with the waiver?
I am satisfied, Your Honor. Thank you so much.
All right. Ma'am, your next court date, as I said, is downtown. That's going to be in 2 weeks, till the 27th of March, 9 a.m. Bond will be continued. Counsel, I'm going to need your signature.
On the approach?
Not yet. I'm not ready for you. I mean, you can come up here and stand. Ms. Redding, I've also got some other files here. It looks like you've got a pretrial coming up on March 14th, 10 a.m. That's Zoom with Judge Martin. That's for a drove while license suspended charge out of Sumter and a registration or plate civil infraction. And we've also got a Romulus charge. Looks like it was pled down to a double parking and you owe $480 due on that one. Are you in a position to set up some kind of a payment plan on that one, ma'am?
Yes, I can set up a payment plan. I'm sorry. What court is that out of?
34th District Court in Romulus. You can do that in person here at the court, or you can go on our website, just Google 34th District Court, and you can set up a payment plan online for that one. But don't forget, you've got a March 14th court date. So that's tomorrow with Judge Martin.
Is that through Zoom?
Correct.
Okay.
You can do that online too.
34. Okay.
You got all that?
Yes, both are 34th District Court.
Correct.
Okay.
Any questions, ma'am?
No, sir.
Good luck.
Oh, yes, I do have a question. Downtown where?
Frank Murphy. You'll get a paper notice.
Okay.
You won't, never mind, you won't get a paper notice.
Thank you, Your Honor. Thank you.
Have a good day. Are we ready on Emery? Appearances, please.
Prosecutor, I'll place my appearance on the record. Good morning, Judge Oakley. Good morning to your staff, Neighborhood Defender Service. Carrie Martin, P 84592, appearing on behalf of Mr. Joshua Emery. Mr. Emery appears by Zoom from the Kalamazoo County Jail. Mr. Emery, please state your full name for the court.
Joshua Michael Emery.
Thank you, sir. Go ahead.
Your Honor, at this time, having spoken with Mr. Emery recently, I am not confident that he understands the nature of the case against him or can assist in his own defense. I am asking that he be referred to the Center for Forensic Psychiatry for a competency and a criminal responsibility evaluation. I believe that once this court sends the referral request, they would be, usually when we send a request, our office gets in the mail the notice of the evaluation. And if he's still at Kalamazoo County Jail, I would be in contact with the CFP to coordinate an in-custody evaluation there.
All right, counsel, so my understanding of the way they're doing things now is unless you file a notice of intention to assert the insanity defense, I cannot order criminal responsibility.
I wasn't aware of that as a requirement, and I do have just recent occasions of in 36th District Court referring for both competency and criminal responsibility without filing any sort of notice. But if you would like me to send a notice to your clerk today, I can do that.
Done.
All right, I'll do
Okay, thank you. Good luck, Mr. Emery.
Thank you, sir.
Will we be setting a review date?
No.
No review date.
I mean, it'll be, I'll just put it in my computer for 3 months, but it's not gonna be a hearing.
Okay.
Can you just recall that one?
Recalling Jared Anderson.
Thank you.
Good morning again, Your Honor. Jeff Osmond on behalf of Jared Anderson. Your Honor, we made a mistake on the bond amendment, the dates.
We had the wrong dates?
Yes, Your Honor.
What do you need?
It's supposed to be tomorrow until the date you have in there. He will
So April
travel.
15th, he's still back in the state, but
He's coming back
leaving.
April 15th, but he can leave tomorrow because there's training camp down there.
Okay.
You can't change the AOI. You can't.
No, he's gonna travel back for the AOI.
He's traveling earlier.
Yes, he's gonna come back in person for the AOI.
Yeah, so that's the 14th. So March 14, travel through April 15.
Yes, sir.
No problem.
Thank you very much.
You're welcome.
And then recall Green. Yeah.
Alexander Green.
Good morning, Your Honor. Petition manager for the people, P 84088.
Daniel Batar on behalf of Mr. Green, Your Honor, he is approaching. Your Honor, we're asking for a final pre-trial on the 27th, where the complainant must appear.
Thank you. I'm sorry, 10:15? March 27, 10:15?
That works.
All right, and looks like there was an out-county arraignment, so bond is continued. Anything else?
No, Your Honor, thank you.
Judge, are we keeping the 4/29/2024?
No.
trial date?
No, scratch that. Mr. Green, I have to give you props.
Thank you, I appreciate it.
You weren't here when after he was smart enough to let me talk for a while, he said, I made a mistake. I watched 20 YouTube videos and they really sent him down a rabbit hole. Fair way to say it? So I give you props for admitting that. I'm thinking somehow I'm gonna have that playing on a loop in my courtroom because I think it gets a lot of people in trouble because they get their legal advice off of YouTube. All right.
We talked about that, Judge, and he's going to make sure in the future he does not do that.
YouTube, entertainment value, not educational value. Okay, all right, we're good.
Thank you, Your Honor.
Thank you, Judge.
Have a nice day.
I apologize, by the way.
No need.
You're good.
You smartened up, so no need. Anybody else got anything ready?
Heather, is Kalamazoo County Jail still on? or-
No.
Oh, okay,
Sorry.
that's fine, thanks.
What do you got, Joe?
Priority waste.
Looking. Yeah, I don't have it, so I'm assuming. Yeah.
Probably no need for him to even be in here.
Yep, then you're good.
Probably don't even need to be in here.
Yeah. 30 days.
very good. Thank you.
Appreciate it, guys. This has been a hell of a day.
Do we have anybody else before the 10:45?
Yeah, bring it back in and I'll update my list too. Please.
So GFL's here, oh, that's a pre-hearing, but they're here.
They've been marked.
Okay, so no Gibson or Langston
Let's see.
or Coltier. 10:00 and 10:30.
No Gibson, no Langston, no Parker.
No, we already did Parker, she was on Zoom. Yeah.
So there's a Coltier.
Coulter, I really like emphasize Coltier. I really emphasize it.
No Coltier.
Okay. I heard him say he's ready for night. Flying on Maine, or cruising on Maine, going to Honduras, Lower Town, Bolivia, Costa Maya, Belize is their private, Belize is their private island, like part of it, so. And then Lower Town is, we have a VIP beach day, so. At the VIP we do, but since it's, oh yeah, the cruise is all. Yeah. I have the sleeve in. After the cat.
Who's got? I got it. You know what? Oh, yeah, oh, yeah. I got it. Okay. 40. Oh, I got one. I know where I get one. You want to miss one? Yeah. Should I leave this here? Take it with me. Judge has it on.
I'm out of here. If there's nothing else left, you just have to answer. Take care.
Want this?
Circuit court calling thing. Aaron didn't will be late, though. Aaron will be there. Okay. With, but Aaron didn't. Wrong court.
Hey, would you mind checking your docket? Tell me who showed up at 10 o'clock. Gibson, Lane, oh, you got it? Oh, Joe just walked in. Joe just walked in. Thanks. Did Gibson show up? 10?
10 o'clock?
Yep.
Don't believe so. We will check. No Gibson,
How about Langston or Parker?
neither one.
Is that, no, Parker we did. Parker was online. Okay. How about Coulter? At 10:30? Priority waste?
Yes, priority waste is
Emory, we did Emory. We just wait for the late shows, the late schedule, I should say. Okay. What time?
At 9:15?
Yeah, I already got that. Yeah. Yep. Yeah, so we're docket wise, we're caught up until the 11 o'clock time. frame.
You got people in there.
Just need them in here.
No perfect.
Yeah, just need them in here. Flippo? Mhm.
Your remote agency, it's gonna be a plea.
Okay.
That's why we changed it to say
Okay.
action, we're set for a trial.
Okay.
So that's on this.
Joe? I got an email that there are homemade Rice Krispie treats in the lunchroom. So, after you go out and get me my half a slab of ribs from the food truck.
don't do that from time.
Hey, have you ever heard of deep fried spare ribs? I met some guys for dinner Monday night. We were supposed to go to this restaurant that started in Lincoln Park called Zubin's. And now it's out there like along the 6 Mile or somewhere. But it was closed on Monday, so we couldn't have it. And so we went to another restaurant. My buddy's like, yeah, but we said, "Well, take you guys there."
I think it, they had a sign that was like a kid.
With the bones in it?
I guess.
Zoomed in.
Yeah. I think so. It's either Zukin or Zubin. I think it's Zubin.
Zukin, Z-K-I-N.
Yeah.
You Spanish, yes.
Yeah, deep fried spare ribs. Yeah. My sausage eggs. Cook them up and stick them on a skewer. Fry those. Sounds like a sausage corn dog. Sausage egg corn.
Well, I just wanted to introduce myself because I'm Donna Sullivan with the prosecutor's office.
Nice to meet you. Nice to meet you.
Yeah. Are you gonna be hanging out with, Mohammed? Yeah.
Donna, pronounce it Soba? So,
Yeah,
like the H isn't there.
Meaning morning, but
Okay.
in English it doesn't translate.
Morning, like,
Morning.
okay, not morning like sad, but.
No, morning like
Okay.
daytime.
Daytime.
Like, I just took the bus home.
Well, welcome.
It's a president here. So you have your number now? Not yet. Hopefully, like end of April. Oh, okay. So you'll be with him this whole time. I talked to my supervisor where they, he got for this meeting.
Where'd you go to law school?
I was,
Wayne?
you too?
Yep.
Great school. See, that's what I love about it. Like, wherever you go, you're gonna have them everywhere.
Yeah.
I'm not gonna ask when you graduated.
Long time ago.
That's where Jack is hoping to get it.
Yeah.
Right? Yeah. You know, the, first up through those bow tie, real nice dress. Yeah, that's where he's trying to get it. If you have any questions, give him my, I used to work in admission at that one. So if he has questions, let him come to me. I'll be more than.
I'm gonna bring him up here right now. Call him.
Yeah.
I'll come and tell him to come up. Tell him I want him in the courtroom.
Because, what is it? In 2 days, the line. That's what he was wondering. And, yeah.
Yeah, we've got 2 clerks going to law school. Jack's going, and then we got Olivia downstairs who won scholarship to Toledo.
Oh, all right. Great. Where you can get it, yeah.
Yeah.
Because her school, because she was going where? Adrian, and, they work with,
Toledo. Yeah, that's right. She did tell me that.
pipeline from undergrad to.
Yeah.
20 times that hour, you do it in 6 years. So when I was in undergrad, I was getting my bachelor's in criminal justice and political science, but then I didn't even drop it.
Right.
So that's something I only do with political science.
Yeah.
And I was so close to finishing, I only had classes like I can't drop the entire major just to get it.
Right.
But it worked out well. Sorry, previous.
Good for you.
First year of COVID.
Right.
Oh, okay, whenever you're done, just really quick about your firm. All right, thanks.
You got somebody to call him?
He's got somebody on the phone.
Okay.
I'll be,
We're gonna send him in to you, Don.
not a problem.
He got into one, but it's not in school of choice. That's what we're talking about. She just came out of Wayne State, and that's where he wants to go. Yeah. You should be proud. Yeah. And I'll tell you what, it's nice to know you got somebody to watch, even if it's not the school, you know, even if it's not your first choice, it's nice to have that in your back pocket, like, I'm going to law school. Yeah. So you know what they call a person who graduates last in law school? Counselor. Just like the doctor joke. As long as you pass the bar, it doesn't really matter what your class band is. We got a formal hearing, did he sign it? What's going on? No.
Roman, I think. I mean, I don't know if that's when he's on, but Roman is our formal.
Yeah. Come on, people.
putting down around.
Oh, that's what we got to tell him. Got to tell Muhammad about that. What was the name of that file?
Boykins.
He's not on Zoom anymore.
No, probably because he's,
Got him all wrapped up.
I know Carrie, I heard him say that Nike is going. Did, Lauren Anderson here for, Did the attorney?
He's talking to him.
Are you waiting on a prosecutor?
Prosecutor's looking into a few different things out there. My next case is Mr. Knighton.
I'm ready.
He said he's got a few before that. I'll let him know that.
Let him know the judge is getting anxious.
I will.
Did, for that Roman family?
A lot of people out
And last week, we had a ton of exams scheduled and only 2 minutes.
What?
Yeah. Really appreciated the one else in the comment.
Yeah, I heard, I got some, I don't know what it was. Hey, before I forget, Boykins. It was a civil infraction. No, DWLS, you were pleading it down to a no ops.
Failure to display, I think.
Right.
Okay,
I dismissed it because it didn't belong here.
okay, I'm good.
The ticket said E-course and Beach Daily, which is outside of my venue.
Okay,
It said Romulus, but Beach Daily is not Romulus.
Okay.
So I called that out, prosecutor. I moved to dismiss. I said, I grant it. So,
yeah, good.
just to let you know.
I'm good.
Yeah, I didn't think it'd make you lose any sleep.
No, definitely not. We're calling Bruman first, correct?
Whatever's ready. I'm ready to work.
Yeah, Bruman is ready.
All right.
They've been here.
You got a file?
I don't. I just have-
Probably, this is a formal hearing, so there is no file.
Yeah.
No, you do have the file for them.
I do?
Yeah. Because she filed a motion, you can write the motion.
Oh, that's right. Yep.
They know we're right out there.
Yeah, I can let him know. He's been here for.
Thanks, Mom. This was a discovery one. Good morning, counsel. Are you ready on Drummond?
I'm ready on both Bivens and Lawrence, they're both waivers.
Bivens and Lawrence. You come up here. Counsel, go ahead and take that counsel's table. I'm gonna do a couple. Yeah, grab it. I'm gonna do a couple waivers before we get started with the formal.
Gotcha.
Which ones did you just say? Bivens and Lawrence. Who you got first?
This is Mr. Lawrence.
All right, come on up, Mr. Lawrence. Counsel, your appearance.
Emily Elijah, 385-029 on behalf of Mr. Lawrence.
Come on up,
Good
Mr.
morning.
Lawrence.
Mr. Lawrence, please introduce yourself.
Kevin Lawrence.
Thank you. All right, Mr. Lawrence, I understand you're going to waive the exam today?
Yes,
All right, and you've discussed your rights with counsel?
yes,
You understand those rights and the options those rights give you?
yes,
And you understand the purpose for the exam?
yes,
And you know, if we waive the exam, that means your next court date's downtown, not at the district court here, but at the circuit court downtown.
yes,
And that's what you want to do today?
yes,
And you're doing this freely and voluntarily?
yes.
Counsel, you satisfied?
I am, Judge.
All right, we're gonna set him up with a 27th of March AOI.
All right.
That's 9 a.m. Bond will be continued. I'm gonna scribble in the file, then I'm gonna ask you two to scribble in the file.
borrow a pen as well, please?
You know,
The same rights and conditions.
Deja Bibbins. Good luck downtown, Ms. Florence.
Thank you, Judge.
Counsel your parents.
Emily Elijah, P 85039, on behalf of Ms. Bibbins. Ms. Bibbins, please introduce yourself to Judge Oakley. Deja Bibbins.
Good morning. All right, Ms. Bibbins, you're going to waive your exam today?
Yes.
Ms. Soul? Mr. Burcraft, go and introduce yourself to that lady. She's got information for you. Thank you, counsel. All right, so you've discussed your rights and options with Ms. Elijah? You understand those rights and the options they give you?
Yes.
You understand the purpose for the exam?
Yes.
You understand that if you waive the exam, your next court date's gonna be at the circuit court level, not here at the district court.
Yes.
And you're doing this knowingly, and voluntarily?
Yes.
Satisfied?
Yes.
Ms. Mohammed, you satisfied too?
Yes, Judge.
All right, I don't want you to fall asleep out there. All right, arraignment on information date for you, ma'am, is the 27th of the month. 9 a.m., bond is continued. And I need signatures. Yeah. More so now.
Thank you, Judge. Have a good rest of your day.
You as well, counsel. All right, gentlemen, your appearance is on the People versus, is it Vrooman, sir? Vrooman?
Attorney Eric Chappell on behalf of Dynamic Transportation, Richard Bruman.
Good morning, Your Honor. Mohammed on behalf of the people, P 86771.
Counsel, spell your last name for us.
Chappell, CHAPPELL.
Thank you.
It's P51332.
Is the officer your first witness? Mr.
Yes,
Muhammad?
Judge.
Yes, Your Honor.
Raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth?
Yes, I did.
Come on, right up here on the witness chair. Watch your step on my ramp. It'll trip you up if you're not ready for it. Settle in that chair. After you settle in, state your name, spell your last name for Heather, if you would.
Sir, Honor, Officer Sahib, Michigan State Police.
Sahib?
Yep.
Spell it.
SAHIB.
Thank you. Have a seat. When you're ready, Mr. Muhammad.
Thank you, Judge. Trooper Sahib, can you please restate your name for the record?
First name Wada, last name Sahib, SAHIB.
And Mr. Sahib, or Trooper Sahib, are you currently employed?
That's officer.
Or Officer Sahib, are you currently employed?
Yes, sir, for the Michigan State Police.
And in what capacity?
I am a motor carrier with the Commercial Vehicle Enforcement Division.
And were you employed in this capacity as a police officer on October 24th, 2023?
Yes, sir.
Did you work this day by yourself or with a partner?
No, by myself.
And on this day, were you working in full uniform or modified uniform?
No, same uniform, full uniform.
On this day, did you work on foot patrol or in a scout vehicle?
Patrol vehicle.
Was this patrol vehicle fully marked or semi-marked?
Not fully marked.
Did your duties on this day of October 24th, 2023 take you at or near the location of westbound I-94 at or near Shook Road?
Yes, I was there.
Is this located in the city of Romulus?
Yes, sir.
County of Wayne?
Yes, sir.
While at or near this location, did you observe something that drew your attention?
Yes, sir. I observed a commercial vehicle, a truck tractor semi-trailer, with the tires that had a really bad squatting on it, and that's what drew my attention.
Okay, this vehicle that you observed, can you describe it?
It's a truck tractor, which is the front unit, and then the semi-trailers, which they follow. It's got 10 axles on it, and that's it's got the front axle, the drive axle, the steer axle, the drive axles, and the following axles.
Okay, now what about this semi truck drew your attention?
What drew my attention is the tires, the squatting of the tires.
Okay, which tires?
The drive axle tires and the tires after that.
Okay, now what do you mean by squatting?
So when you look at a tire, it should look like almost like a full circle, right? These tires did not look like almost like a full circle. They had a really bad squat on it, like a half a donut, let's say.
So just for clarification, you mean it didn't look fully inflated? Like a
Yep.
fully
So
inflated?
it looks like a flat tire, almost a tire that's half inflated. That's what
Okay.
it looks like. So
Okay, upon observing that, but prior to strike that, what is that, based on your training and experience as a police officer, what is that indicative of?
it's usually a sign of overweight.
Okay, okay, now based on this observation, what, if anything, did you do?
So I followed the vehicle, got next to it in the third lane. So I kept observing it, took a second look, confirmed, yes, he is overweight, which it looks like. So I made the stop.
How did you make a stop?
Turn my lights on, initiated a stop.
Okay, did that vehicle pull over?
Yep, to the right shoulder.
Okay, and what did you do when that vehicle pulled over?
I went to him, I introduced myself, who I was, and I told him why I'm stopping him.
By him, who are you referring to?
Mr. Richard Druman.
Is that the individual? How many occupants did you observe in the vehicle?
Just one occupant.
And is that in the driver's seat?
Yes.
Okay, that driver that you observed in that vehicle on that day, do you see that individual in the courtroom?
Yes, sir.
So stipulated, Your Honor, Mr. Druban was a driver.
Thank you. Appreciate that.
Okay, and upon did you make contact with this individual?
Yes, sir, I did.
Okay, and what occurred?
I told him why I'm stopping him, and I asked him about the axles, if they were.
And why did you stop him?
I stopped him because he was, he looked to be overweight, and that's why I stopped him.
Okay, and what occurred next?
I told him I'm going to be escorting him to the Belleville rest area, and that's where I'm going to be confirming the weights.
Okay, and did you do that?
Yes, sir, I did.
Okay, and what occurred next?
What
did you do next?
What did I do next? I followed him to the Belleville rest area. We pulled in there. We have a little cutout in the ground. It's a location where it's like safe and away from the public a little bit. So we can do our weights there. So.
Okay, and did you check the weight there?
Yep, I do have portable scales issued by the state of Michigan. They're certified and calibrated. I got my scales out and I instructed him how we're going to be doing the weights. We're going to do it axle by axle as close as we can. And then that's how I confirmed the weights.
Okay. And did you complete those tests?
Yes, sir, I did.
And what was the results of those tests?
Turned out to be he was over gross of 10,000 something, I can't remember. But I have an axle by axle.
Would referring to your citation that you wrote up refresh your recollection?
Yes, with my citations, I have them axle by axle. So he was 2,500 pounds over on axle 2, 1,600 pounds on axle 3, 5,200 pounds on axle 5, and 5,400 pounds on axle 6, and then 300 on axle 7, 400 axle 8, 300 axle 9, 500 axle 10.
Okay. Your Honor, may I approach the witness?
Sure.
I've handed you a document. Do you recognize it?
Yes, sir.
Your Honor, I'm not sure what it is.
Oh, I'm sorry.
That's fair.
Okay. Thank you, Your Honor.
You're welcome.
Yes, sir. That's my citation, the citation I wrote that day.
Okay. And does it appear to be a fair and accurate description and depiction of what you wrote on that day?
Yes, sir. It is exactly what
And to your knowledge, does it appear to be manipulated or altered in any way?
Nope, that's my citation.
Okay. Your Honor, at this time, the people would like to introduce into evidence and publish to the court People's Proposed Exhibit number 1.
Mr. Chappelle?
No objection, Your Honor.
Thank you. Am I saying, or is it Chappelle or Chapel?
Well, Your Honor, I guess it's Chapel.
Thank you.
mean, obviously, the ticket is a ticket, Your Honor, but relative to admissibility, I mean, I think the ticket is authentic, but I don't want the court to believe that we're stipulating to everything that's in the.
Oh, I got it. Yeah,
Okay, all right,
yeah.
thank you.
We can still argue what the ticket means.
You got it. Thank
Yeah,
you.
I'm with you.
Yeah.
Go ahead.
And do you recall what the legal limit was in regards to that citations for those axles?
I do have the legal limit on the citation as well. So he's allowed 18,000 pounds on axle 1, 16,000 on axle 2, 16,000 axle 3, and then 13,000 for the remaining axles. He cannot be exceeding those limits. He does get 1,000 grace period, according to the state of Michigan. So if he's within 1,000, under 1,000, so he's allowed 13,000 pounds, right? So if he's 13,900, we kind of don't write that. But unless he is over gross, we write everything. So let's say if he's over gross, so if I put these together and he's at like, let's say he's allowed 141,000, right? If he exceeds that 141,000, we write everything. Even if he's 500 pounds over, we write the 500.
And was this individual over gross?
He was over gross. So if you put everything together where he's legal at and then where he's actual at is going to be 10,000 plus.
And those instruments that you use to check this weight, you mentioned it was calibrated.
Yes.
Appear to be functioning properly and accurately.
Yes, sir. We do calibrate them every year by the state of Michigan.
Every what?
Every year they get calibrated and certified, recertified or calibrated.
Besides the vehicle, when you initiated the traffic stop, besides the vehicle, appearing to be squatting, the tires to be squatting, besides it just being a ticketable offense, was there any other reason you wanted to pull over this vehicle? Is there any other concern you had?
I mean, it's a safety hazard. It's either, so when I see one axle that looks like that it has flat tires, I stop it because a flat tire is a violation. That flat tire can blow any minute. It can leave debris on the highway. People try to avoid it, and that's how accidents happen. But if it's multiple tires that look flat, then yes, most than likely he's overweight. So either way, I can pull him over for either a flat tire, underinflated tires, or overweight.
Judge, no further questions.
Counsel, your witness.
Thank you, Your Honor. And just so we, housekeeping matter, Your Honor, we filed a couple motions or one motion. We received a message from your office indicating that the motions were being denied. So one of them was a motion to suppress. So because we argue under 257.724 that there has to be a reason to believe by statute. Am I allowed to ask questions?
Yes.
Okay. All right.
My intention was we'd argue that today.
Okay, gotcha. And the other one, Your Honor, is an argument we've been making. We have a couple of decisions, but we intend to take something up to the Court of Appeals. It's some.
You're just not gonna do it on mine.
But I think I talked to you about this before
I
when
think so.
we were here, but it has to do with the civil infraction rules and discovery. These are pretty large tickets, so, but that's, we actually have a case out of Burton, Michigan that looks like we'll probably be the first one. We'll file an appeal on that.
Yeah.
So thank you. Officer Sahib, how long have you been, working in your capacity?
Just a little under 2 years.
What's
Under
that?
2 years.
Under 2 years?
Yes.
Okay. So, and how long have you been working on your own? Same time period, or did you have a training period?
No, on my own since probably January of 2023, I believe.
Okay, gotcha.
Don't quote me because
That's all right. Just want to kind of get a sense with respect to that. Now, do you have any specialized training with respect to tires?
Not specialized, but my previous job was a truck driver.
Okay.
Yeah.
And so any tire engineering or anything like that, how tires are constructed?
No,
et cetera?
absolutely not. No.
Okay. Now, the one thing that I noted, and we did have, we have a video, and when I looked at the video, I just want to confirm a couple things. Hopefully we don't have to go through the video with you today. When you stopped Mr. Vrooman's vehicle, didn't look like you made any notation to see what kind of tires were on the truck. Is that correct?
Nope.
Okay.
I don't care about.
You acknowledge, do you not, that there are all kinds of different manufacturers out there for truck tires, correct?
Yes,
Okay.
absolutely.
Every manufacturer has different load requirements, correct?
They're very close in similarities, but yes,
Okay.
you're right.
Well, I mean, you can buy a tire that has the ability to carry higher loads versus another tire that's out there, correct?
Objection, speculation.
Yeah, maybe it is. Let's see if you can answer.
Okay.
But they're very close when it comes to weight, like drive tires, axle tires, and the remaining tires for the axles.
Are you, is it your testimony that every manufacturer has the same load capacity for truck tires?
No,
Okay. Manufacturers have different load capacities depending upon what those tires are, correct?
correct.
Okay, and again, you're not here as an engineer to talk about,
No,
you know, this was a good year, you know, this type of tire, and here was the load requirements and things such as that, okay?
you're right.
All right, now relative to this issue of squatty tires, inflation has something to do with how a tire reacts under pressure as well, correct?
Correct.
Okay, and the one thing I noted on the video was that, and not seeing you note anything with respect to the manufacturer of the tire, you also did not check the inflation of any tire on either the tractor and or the trailer of this vehicle, correct?
I did not know.
Okay, so you have no idea what the inflation was on those tires. I assume you don't know what the inflation specifications were because you didn't know what the manufacturer was, correct?
Correct.
Okay, so if a tire had been underinflated, that would be an indication as to, that could cause a tire to look flat as well, correct?
Yes, like I said in the beginning when I was talking to the prosecutor, if I see one axle that appears to be underinflated, I pull them over and I tell them like, hey, we're gonna check these tires because it's one axle. But if it's multiple axles that look flat, then yes, it's an overweight. So both situations are
An underinflated tire can cause it to look flat, correct?
yes,
Okay. Different tire manufacturers will flex differently depending upon the load they're carrying, correct?
I'm not an engineer, I'm gonna say.
Okay, all right.
I don't know.
And relative to the tires here that you were concerned with, and I know it's been a little bit, you were in particular concerned about the lift axles
Yes.
on this tractor when you pulled over Mr. Vrooman, correct?
Yes,
Okay, so it wasn't, you mentioned to the prosecutor that you were focusing on the drive tires as well. That's not accurate. You were looking at axles 4, 5, and 6, which are the lift axles on this trailer, correct?
yes, well, I look at all the axles, but specifically I looked at the lift axles and I asked him specifically about the lift axles. Because some drivers do make a mistake and they don't know how to control the pressure of those axles. So sometimes I'd be cutting them a break after I confirm their weights to be like, hey, you made a mistake. You need to loosen up some of the pressure. So you don't look, so you're not overweight and you don't look heavy when driving down the road. And so sometimes I'd be cutting them a break and not writing them a citation if they just left from a location where I stopped them at. So if they just left from a location like a mile away and I stop them, and I make them do the corrections, take some of the pressure off of the lift axles, I let them go with a verbal warning, not write the citation.
All right, so that's another reason why a tire might look flat and or squatty is that it could be a reflection of what's going on with the lift axles.
Yeah,
correct?
but we can still write the ticket for the overweight because they
Well,
can't.
you only get I'm focusing on the stop right now. So we're
Yes.
going to talk about the weight in a bit. But what I want to make clear is that on this particular stop, and if it would help you to get the video out to refresh your recollection, you were concerned about axles 4, 5, and 6.
Yes, but I still looked at the drive axles too because they looked heavy.
Well, let's go ahead and.
I'm not sure how you're going to see in the video where I look at when I'm driving.
It's what you say.
Okay.
It's not what you're looking at, sir.
Okay.
You know what I mean? I just kind of put it up here to.
Sorry with me.
I'll stipulate to the introduction of any video.
Okay.
Oh.
If you want to listen to it all. happy
No,
to
I
go
don't
ahead
have to
and
listen to
queue
it.
up.
I just respectfully request an offer of proof of what you're trying to show.
I put refreshes recollections to why I said stop.
I remember what I said to him. I stopped you because of the lift axles. Yeah. But I don't just look at the lift axles when I drive.
And again, the reason for the stop is important. Okay? So do you acknowledge that the reason you stopped was that the lift axles 4, 5, and 6?
Nope. I stopped him for all the axles. I told him I stopped you because yes, your lift axles look heavy, but I just don't look just at the lift axles. I look at all the axles.
I want to, let's listen to the video.
Respectfully, I'm gonna object to lack of specificity. I don't really know what's happening.
I can't hear you.
I'm objecting to lack of specificity. I don't know if there's a specific question that was asked.
Well,
He said,
I'm not even gonna rule on that because I think, correct me, but I think the officer is willing to stipulate that all he verbalized to the driver was lift axles 4, 5, and 6.
I didn't say 4, 5, and 6.
You just
All the
said lift axles.
Lift axles, yes.
You didn't number them,
I didn't know how many,
Okay.
I don't even know how many
Okay.
lift axles he has.
but you didn't tell him, hey,
I didn't even.
all your axles look heavy to me.
No, I asked him, are those lift axles? I didn't even know if they were
Okay.
lift axles.
Okay. So I think where we're at is, defense can certainly argue that if he only said, I'm looking at your lift axles, that's why he stopped it. He can take the position, I stopped him for all kinds of reasons. All I mentioned was the lift
Yes,
axles.
exactly. Yeah.
All right. I don't think we need the video for that.
Well, and I don't want to make too fine a point of your honor. It actually does say lift axles on the video.
No, that's what he said.
I said,
He
are those-
agrees
I
that
asked
he
him, are those
said
lift axles?
your lift axles look heavy.
Yeah. There are several other reasons why a tire may look squatty that has nothing to do with the weight that it's carrying, correct?
It's either underinflated or weight.
I'm gonna object, that's speculation. He's not a tire expert. He said he's observed squatty tires, and so that's the basis of his pullover. I mean, whether some tires are.
You know what? I'll take judicial notice that there could be other reasons why a tire would look squatty.
Okay.
I don't know. It's either underinflated or overweight.
Okay, or the lift axles could be misaligned to where they're carrying more load than what they should, as you described previously.
Objection, speculation.
Well, it was his testimony, not mine.
I've already taken judicial notice that overweight's not the only reason a tire could squat.
Okay. Okay. Do you, and as part of your practice and your daily duties, you fill out a daily report, do you not?
Yes, sir, I do.
Okay. And with respect to that daily report, you specify, you provide information for every stop that you make on that daily report, correct?
Yes, sir, we have.
Is that daily report turned into the Michigan State Police on a regular basis?
On daily basis, yes.
Okay. And within the daily report, you're required to indicate why it is that you stopped the vehicle, correct?
Yes, sir, I do.
Okay. Did you produce a copy of the daily report in this case?
To my sergeant, yes.
Okay. You don't have it with you here today, correct?
No.
You didn't produce it to the prosecutor, correct?
No.
That daily report would contain what you put down on it on that day, why it is that you stopped Mr. Vrooman, correct?
Yes, sir.
Okay. Relative to scales and certifications, the things that you testified about, there are actual written documents with respect to certifications of scales, are they not?
Are you asking there are documents?
Yes.
I don't have access to those.
Okay.
It gets done by the state.
All right. Do you know that there are written certifications?
If you know.
I don't know.
You don't know?
I know we turn them in every year to get certified.
Okay.
And then I turn them in to my sergeant. I'm pretty sure my sergeant has some kind of paperwork or documents to prove that.
Okay. Are you involved in the certification process?
No.
Okay. Someone else is responsible for that?
Because I'm not certified to recertify scales.
Okay. All right. So you know nothing about what documentation may or may not be out there then?
Yes, I do not know.
Okay. Nothing further, Your Honor.
Mr. Mohammed, anything further for the officer?
Yes. Officer, you mentioned that you checked the weight of the vehicle using some instrument.
Portable scales.
Okay, now how do you know how to use those?
We get trained on them.
So you were trained in using those scales to weigh vehicles?
We got trained at the Michigan State Police Academy, and after we graduated, we had hands-on training on the road.
And you used that training on that day when you weighed that vehicle, correct?
Every time. Yep.
And that vehicle on that day was overweight, correct?
Yes, sir, it was.
And that citation that I produced to you earlier, that's the same citation for that same vehicle on that day, correct?
Yes, sir, same citation.
For that same semi-vehicle that you weighed that was overweight?
Same semi, yep, semi truck.
Nothing further, Judge.
Nothing further. Thank you.
Officer, you can step down. Thank you. Anything else from the people, Mr. Mohammed? Counsel?
Nothing from us, Your Honor.
Argument?
Judge, the people would like for the court to find that the defendant is responsible for the citation. As you know, the standard of proof here is preponderance of the evidence, which means, over 50% that this individual is responsible for this citation. And based on that, and based on the testimony that was produced today, the people believe we've met that burden and would like to request for this court to find the defendant responsible. Thank you.
Mr. Chip.
All right, thank you, Your Honor. Number one, got a couple arguments, but the first, maybe the easiest way to resolve the case, Your Honor, is I think there's been a failure of proof. Under 257.7241, the statute requires that there has to be, that the weighing of the vehicle has to be by a portable or stationary scale approved and sealed as a legal weighing device by a qualified person using testing equipment certified or approved by the Department of Agricultural and Rural Development as a legal weighing device, as one of the requirements for finding that there's a violation in any case. I think I've had at least one other case in front of Your Honor where the prosecutor actually brought in the certifications. I believe that is an element that has to be met by the prosecutor. The officer testified he had nothing to do with the weighing. He has no ability to say that they're certified, sealed, or anything. There's no proof of it. So I think the prosecutor has failed in its proof to find Mr. Vrooman or Dynamic responsible in that regard. They have not complied with the statute. Secondly, Your Honor, depending upon your ruling with that.
Let's do this.
Okay.
Let's argue one at a time.
Okay, thank you. Yeah.
Mr. Mohammed?
Judge, the testimony made by the officer was that the scale that he used on that day was produced by the state of Michigan and used by the Michigan State Police. There's no evidence that was produced today on the record that would show that it wasn't proper, anything about it not working on that day. The officer testified it was working properly, he used it, and there was no issues. So I would rebut that argument.
The problem is, I think you're shifting the burden of proof. If counsel's interpretation of that statute is correct, the burden's on the people to, as a element of the case, show that the scale is certified today. If I got your argument right.
We believe it is now.
Yes. Yeah. And trust me, Mr. Mohammed, I know you don't have that statute or memorized. Counsel, you got a copy?
I do. I just have it on the phone, Your Honor. I mean,
let counsel look at it.
Okay, I can look.
If you don't mind.
Yep.
And my understanding is whenever there's case law going to be used,
This isn't case law. He's saying the statute requires you to prove certain things today, and one of the things you didn't prove that's required is that the scales were properly certified. Am I getting your argument right?
You are.
Okay.
Every year.
The trooper's gonna, or the police officer's gonna contact the supervisor to see if he can have it emailed to the court.
Well, Your Honor, we're here today for a hearing. I mean, I think we're done.
That's why discovery process works. Case dismissed.
Thank you, Your Honor.
Mohammed, that's a cheap lesson. Counsel, drive safely.
Yeah, thank you, Your Honor.
Counsel, that's only the second time I think I've had that argument made. And I think it's a game changer when the word gets out.
Yes.
Because they can't afford to have a body here all the time.
Correct.
But should be a fairly simple legislative fix.
Yes, yes.
Yeah.
The court rule is the one I'm kind of interested in, so, not the boring, but still not getting discovery in civil infractions.
Right.
I will say the prosecutor's office is pretty decent about it.
Yeah.
But some take a really hard line.
Yeah.
And when you look at the legislative intent behind the rule, it's for tickets that are $25, $50.
Right.
These are like $8,000, $9,000.
Yeah, once again, it's an easy fix, right?
Right.
Carve out overweight tickets.
Exactly.
Right,
Yep.
right.
So
Or say exactly what's, limit the discovery.
Right.
Because all you guys want is those records,
That's it.
right?
That's it. Yep.
Yeah, yeah. Good luck.
I gave it to.
Yeah, yeah. Caitlin field it. It'll be interesting. Let me get some water.
Yeah. We can. I don't know.
Hey, Mohammed.
Yeah.
The last time I had that argument, it was even more than that, because the statute seems to say they gotta have a body here,
Yeah.
right? So that was Huron.
Yeah.
That was only a couple months ago.
Yeah.
I don't know if you know Mike Levitt or not, but he does a lot of overweight tickets. The attorney represents a lot of aggregate holders. And he made the argument, they gotta have a body here that can testify about the certification process.
Wow.
And the statute, I think, is pretty clear.
Yeah.
And I said, you're right, case dismissed. That one's being appealed. Huron Township's appealing that. I'm telling you that just to be forewarned that the documentation alone might not do it for the next argument.
Wow.
Which is a game changer. $2,000 ticket, you can't afford to have, somebody from the state of Michigan down here to talk about certification of scales.
Yeah, that's wild.
What's going on, masked man?
Oh, just got domestic today. So, how are you, man?
Good, Phil.
Dropped an app off.
You dropped a who off?
App off.
Oh, app.
Yeah.
I thought-
Yeah, not an app, the old.
I heard app off like one word. I thought you dropped your app off.
Yeah.
I didn't know what an app off was. Joe, give me some work.
Good morning, Your Honor. I'm the APA, I'm Kazoo. The defense attorney is in the hallway, the defendant is in custody. We are actively.
What's the name? Kazoo?
We are actively working on a proposal to you because this is a very unique
Okay.
case with unique issues.
When you
Not
say
unique,
that,
but-
when you say the defendant's in custody in my building?
Yes.
Oh, okay. All right, you scared me. I'm like, what the hell? He's not here? She? Whatever happened to, I thought Mr. Martin was ready to go on night.
Yeah. Judge, where are the probation folks at?
Downstairs.
Downstairs. And is there someone that's in today? Should I ask for a specific person?
Probably Shannon's here, unless she's at lunch.
Emily would be, it would be you, it would be Emily.
Yeah, what are you after?
I just want to talk to Shannon or Emily about some creative language to capture, to make sure that
Yeah.
the agreement that we might enter into is proper.
Probably either one of them can help you with that.
Pardon?
Either one of them could help you.
Yeah.
You want to see if I can get one of them up here?
Sure. And they, I don't know that we're gonna enter into it today, but.
This whole day has just been like. doo-doo-doo, doo-doo-doo.
Well, and then if you look at my data,
I know. Yeah.
so it's like the whole 18.
What was that?
Megan's gonna be an example.
Then tell them to get their butts in here. Schedule it at 11 o'clock. At some point, I want to go home today.
Clark Spangel. The other attorney?
He's on the political case.
Scoot over. I'm just saying. He said you don't.
When we're done with this, I'm gonna go check out that food truck. Is it any good?
I don't know anything about them.
I'm hungry.
Yeah, I don't know anything about them.
Looks like he's cooking some barbecue out there.
It's barbecue, right? How could it be bad?
That's probably true. The food truck looks really nice. Have you done barbecue out there?
Officer Garcia, have we done a quality check on the food truck?
I went out there and saw one customer, I not been able to get reviews, but I can.
That's fairly useful.
Okay.
No.
This court is so accommodating. I wish they could just send me out here for me.
We try to make sure we're all here.
Well, I'm a little bit disappointed in that review or lack thereof. I mean, they've been out there since 9 o'clock this morning.
I've been following footsteps of your poor. Speaking of good reviews.
Counsel, this is Emily Tiroli from our probation department.
Hi, Emily. Okay, so.
Emily, you're not in trouble. You look like you walked in here ready to get yelled at.
A1 case, and the defender is in custody. Okay. And she is paralyzed. The victims in this case are her parents or her dad, and they're not coming today. Nevertheless, I can proceed without them. And instead of doing that, we're potentially agreeing to add duty with probation. My question to you, the defense attorney is finding someplace on the other side of the state that she can be tethered to. And I'm going to make sure that I include the right language to ensure that she gets the treatment that she needs and that she's transported there and everything else.
Yeah, so typically, so do we know where she's going on the other side of the state?
Lauren Anderson is the defense attorney. She
Come on, Martin.
I will confirm. That's what she told me before you guys go.
Yeah, she identified one in Grand Rapids and one in Ohio.
Okay.
But it sounds like maybe Grand Rapids would be.
Yeah, so Grand Rapids would probably to just essentially complete treatment with tether to
Yeah.
agency treatment.
So we want to do 2 years of probation under AD. She needs treatment, she needs a psych evaluation. I want something to force her to
Right.
be treated and force her to. Because she cannot. She's gathering. You know, so.
So typically, I mean, it's like, especially psych eval within the 21 to 30.
Counsel, how are you?
With documentation to probation.
dismissal
and waiver.
I'm ready for work, so if you get somebody in.
Torty and Smith.
Torty, T?
T is, yep, T 40 is the waiver.
I got them both.
Smith is the dismissal. I think, because there's no complaining.
Probably a good assumption.
So is there any
Well,
special?
let's see if, unless,
Unless
yeah, Mohammed says I just talked to him, they're not coming.
Obtain. With you think 21 to 31 days?
Yeah, typically we get 21 to 30 days.
Within 21 days. Okay, obtain psychological relation within 21 days. At the treatment facility.
Which one you want to start with?
Mr. Torty is the waiver.
Mr. Torty, come on up.
So we need a prosecutor to do dismissal.
Counsel, your appearance.
Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Torty, P77960. Mr. Torty is present with me in court today. May you state your name for the record, Mr. Torty?
Mark Anthony Torty.
Thank you, sir. Mr. Torty, did you discuss your rights and options with counsel?
Yes, sir.
You understand those rights?
Yes, sir.
You understand the options presented?
Yes.
And do you understand the purpose for preliminary exam? Probable cause hearing. The prosecutor would have to prove that there was a crime committed on January 10, 2024, and there's reason to believe that you were involved with the commission. If I answer both those questions with a yes, then the case would go downtown for further proceedings. You understand that's what the exam's all about?
Okay.
Is that a yes? You understand that?
Yeah.
Okay. My understanding from counsel is you want to waive the exam and just have your case go directly downtown. Is that correct?
Yes.
And you're waiving this exam freely and voluntarily today. Is that correct, sir?
Yes, sir.
Counsel, are you satisfied?
Yes, Your Honor, I was put on the record that the reason for the waiver is diversion. We've been in touch with the Wayne County Prosecutor's Office, and there's an agreement to diversion in this case if he was to waive the exam.
Good for you. Good for you. Good luck downtown. All right, so you're satisfied, counsel, that the waiver's knowingly?
Yes.
So I'm going to give you a court date for downtown, which is 2 weeks from today, the 27th of March, 9 a.m. Bond will be continued, and I'll wish you luck downtown. Counsel, I need your signature and Mr. Torty's.
Okay. Who is on the other list? Yeah.
Are we ready on Smith?
Yes.
Mr. Torty, just step aside just a little bit.
You can sit right.
Appearances on Smith, please.
Good afternoon, Your Honor. Patricia Mandernick for the people, P84088.
Good morning, Your Honor, or good afternoon, Your Honor. Sophia Nelson, of Neighborhood Defender Service, on behalf of Mr. Smith, P77960. Mr. Smith is in court with me today. Mr. Smith, can you state your name for the record?
Thank you, sir.
Your Honor, today is the date and time set for the preliminary exam. Complaining witness is not present. She has been advised at this date. I would ask that the court dismiss without prejudice.
I would move for a dismissal as well, Your Honor.
All right, dismissed without prejudice. I don't see any cash bond to deal with, so Mr. Smith, you're done. Have a nice day.
Thank you, Judge.
And just for the courtroom at large, I do have a review on the barbecue truck in the parking lot. The wings are sold out,
Oh,
so that's a good sign. Everything else is available.
Your Honor, Mr. Smith does have a tether on. Will you please send a order?
Heather?
Dismissal?
Done.
As soon as I hit enter, I will give you a registered action for the signature. And then when I don't have the email one, but he'll have one on.
Thank you.
George Lyons is in our waiting room.
27. Your Honor, you said 27 for 40, right?
Correct. Good afternoon, Mr. Lyons.
Your Honor, I apologize for being late. I got stuck in probate court.
You're all right. You're all right. Do you have your client with you?
right here to my right, Your Honor.
All right, and what are we doing today, counsel?
Believe I talked to Mr. Mohammed that they're going to not prosecute the matter.
Say that again, sir.
Believe the people are going to nolly the criminal matter.
All right. I had Mr. Mohammed in here a second ago, but I lost him. So
he moves fast.
Joe, tell Mohammed I've got Mr. Lyons on Zoom for Filippo, and I'm ready to do that and Knighton or whatever that exam is. Thank you, Detective. Mr. Mohammed, on Filippo, what's the people's position?
Yes, Judge, I have the complaining with Mohammed on behalf of the people, P86771. I have the complaining witness with me here present today. He indicated to me over the phone that he doesn't want to move forward. I would like to just voir dire.
Sure, go ahead.
Possible. Mr. Spangle, were you coerced, harassed, or threatened in any way to indicate to me that you did not want to move forward?
No.
And is it your wishes today that you do not want to move forward with this case?
Yes.
Are you 100% certain?
Convinced.
All right.
100%.
The only cross from the people?
Correct, Judge.
Mr. Lyons, I'm assuming that's okay with the defense.
No objection, Judge. Thank you.
All right, and I don't have a cash bond, so nothing to deal with there.
All right.
Have a good day, gentlemen.
Thank you.
Mr. Spangle, thank you for your time, sir.
Thank you.
Mr. Mohammed, don't you leave my courtroom. When are we going to do night? And it was scheduled at 11 o'clock.
I'm ready to go.
All right. Do you need to leave my courtroom? Did you do anything?
Just wait.
Gentlemen, your appearances on the People versus Charles Knighton Jr., please.
Good morning, or good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Good afternoon, Judge Oakley. Good afternoon to your staff. Neighborhood Defender Service, Carrie Martin, P84592. I'm here on behalf of Mr. Charles Knighton, who sits to my left. Mr. Knighton, state your full name for the court.
Charles Knighton Jr.
Thank you, sir. Fellas, are we ready?
Judge, the people are ready to move forward.
All right, let's put a witness on.
This is a quick preliminary matter. I'd like to request a mutual order of sequestration with an exception for the officer in charge, which is Detective Rice.
No objection.
Thank you.
Also, as a preliminary matter, I'd like to introduce into evidence as People's Exhibit number 1, pursuant to 76611B, a certified copy of convictions of the defendant, which will show that he was not allowed to possess a firearm on that day. Also, I'd like to introduce pursuant to 76611B, a copy of the MSP lab report, which will show that the drugs that were collected on that day were tested positive for cocaine.
If I could just review what you plan to. No objection, Your Honor.
Thank you for the stipulations.
Yes. Number 2. Thank you. The people call Officer Paquette. It's spelled, for the record, P is in Pat, A-Q-U-E-T-T-E.
Officer, come on up. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth.
I do.
Watch my step or my ramp over here. I want you in this chair over here. So don't trip up on the ramp. Settle in. State your full name And spell your last name for Heather.
My name is James Paquette. My last name is spelled Paquette.
Say your last name again.
Paquette.
Paquette, thank you.
Officer Paquette, are you currently employed?
Yes,
And who is your employer?
Romulus Police Department.
And in what capacity are you employed by the Romulus Police Department?
Certified law enforcement officer.
And did you work this day on December 7th, 2023 as a police officer?
Yes,
Did you work this day by yourself or with a partner?
by myself.
And on this day, did you work in full uniform or modified uniform?
Full uniform.
And on this day, did you work on foot patrol or in a scout vehicle?
In a scout vehicle.
Is the scout vehicle fully marked or semi-marked?
It is fully marked.
Did your duties as a police officer on December 7th, 2023 take you at or near the location of Merriman and Flynn?
Yes,
Is that located in the city of Romulus,
it is.
county of Wayne?
It is.
While at or near that location, did you observe something that drew your attention?
I did.
What did you observe?
I observed a white and red Ford Fusion go through a red light northbound Merriman. It stopped in the middle of the intersection and then it reversed back past the stop line.
Okay, upon observing this vehicle drive past the red light, what, if anything, did you do?
I initiated a traffic stop.
Why did you initiate a traffic stop?
He violated a motor vehicle code law.
Is that a ticketable offense?
It is.
Okay, how did you initiate a traffic stop?
I activated my lights.
Okay.
And got behind him.
And did that vehicle pull over?
It did.
Okay, and what did you do when that vehicle pulled over?
I made contact with the driver.
Okay, that driver, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
A blue suit right there.
Noted.
Thank you. How many occupants did you observe in that vehicle?
Just one.
Okay. And which side did you approach on that vehicle?
The driver's side.
Okay, and did you make contact with that driver
I did.
that you identified in court?
Yes.
Okay, and what occurred when you made contact, if anything?
I asked for his driver's license, registration, insurance.
Okay, did that individual produce a driver's license or insurance?
He did.
Okay, and what did you do next?
I went back to my vehicle, ran the driver's license through Lean SOS.
And what was the result of that, if anything?
His status as a driver was suspended.
Okay. Okay, and what did you do next, if anything?
I made contact with the driver once more. I advised him to step out of the vehicle.
We'll strike that. Prior to stepping out of the vehicle and approaching the defendant, you said you observed that the individual's license was suspended, correct?
Yes.
Was that using lien?
Yes.
Is that what you mentioned? Okay. Did you discover anything else?
He was a convicted felon. There was a lien notification.
Your Honor, I'm going to object to a question. I'm going to object to Officer Paquette testifying about criminal history results coming through lien. That's not, we already, first of all, it's redundant. We already admitted and I stipulated to the record of conviction. And secondly, I don't even think it's true, as there was follow-up conversation, not through lien, the officers had trying to run Mr. Knighton's CCH. So I would just rather.
Well, with the stipulation of his record, do we care? Do we need any testimony about his record?
No, I mean, it wasn't even just, for me, it wasn't about his criminal history. There's other things in regards to the reason for the pullover that I think he discovered through lien, not his criminal history.
Okay.
And I can show it to you if you'd like.
Maybe you could rephrase the question and I won't object even if it's a leading question, if you're looking for something specific in lien. Fine.
You mentioned you performed the lien search. Besides the criminal history of him being convicted felon and the suspended license, was there anything else you discovered?
The license plate on the vehicle was expired. and there was no insurance on the vehicle.
Okay. Are those ticketable offenses?
There,
Is having no insurance an arrestable offense?
no,
Is driving with a suspended license a arrestable offense?
yes.
Okay, upon the discovery, what, if anything, did you do?
I asked Mr. Knighton to step out of the vehicle to issue him a citation and release him from the scene.
Okay, did you issue a citation?
I did.
Okay, after you issued him a citation, what, if anything, did you do next?
I called for another unit to come to the location to give Mr. Knighton a courtesy transport home.
A what? To give him a what?
A courtesy transport.
Okay. And did you observe anyone arrive from the police to give him a courtesy drive?
Yes.
Who did you observe?
Officer Reyna and Officer Otter.
Okay. And what did you do next?
Once the courtesy transport was figured out, I conducted an inventory search of the vehicle because the vehicle is going to be impounded for our department policy. Once I conducted an inventory search of the car, I located a firearm in the trunk of the vehicle. It was wrapped in a t-shirt in a bucket.
Okay, can you describe this firearm you recovered?
It was a black pistol.
Okay, was this firearm loaded?
There was no round in the chamber, but there was ammunition in the magazine of the gun.
At any point during your interaction with the defendant, he produced a CPL license?
No.
Upon this discovery of this firearm, what did you do next?
I had Romulus Dispatch run the firearm serial number through Lean to see if we could return. The firearm came back unregistered.
Okay, and what did you do next?
I advised I just had the vehicle impounded. And Officer Reyna and I discussed the scenario based on him being a possible.
I'm sorry, you discussed what?
The scenario of him being a felon in possession of a firearm.
Okay, what did you do next?
After, what exactly are you asking?
So you said after you recovered this firearm, you contacted your partner or
Yes.
Officer Reyna. What did you say or do next?
We were trying to figure out when his last conviction of a felony was, for the statute, to see if he actually was a felon in possession of a firearm.
Okay.
So
and then after that discussion, what did you do?
We had to contact Romulus Police.
What did you do?
I contacted Romulus Dispatch to conduct or print out a CCH of his criminal history.
Okay, what did you do next?
After finding out that he was a felon in possession of a firearm based on his criminal history, I transported the firearm back to the Romulus Police Department.
Okay, now while at when you discovered that CCH issue, did you relay that to anybody?
I can't recall.
Okay, no worries. You went back to the station, is that correct?
Yes.
Okay, what did you do next at the station?
I met Officer Reyna, Officer Otter, and Mr. Knighton in the booking room of the police department.
Okay, and while in the booking room, did you observe anything?
Yes.
What did you observe?
Mr. Knighton, I observed him pull a ball of marijuana from his crotch. And then there was also crack cocaine in the booking room as well.
Okay, now upon making that observation, what did you do?
I took possession of the narcotics.
Okay, and what did you do with the narcotics that you recovered?
I placed them on evidence.
Okay, do you recall the evidence tag number associated with those drugs?
I can't remember the exact number, but it's the case number.
Would referring to your report refresh your recollection?
It would.
Your Honor, may I approach?
Sure.
And I'm gonna give it to you.
While you do that, I've got another public service announcement. The ribs are excellent. They've received the Jack Burkroff seal of approval.
preserved forevermore in the transcript.
When your memory's been refreshed, look up at me, so. And you don't have to memorize it all at once. You can remember, the first 3 or 4 numbers, look up at me, you can state it, then to refresh your recollection as to the next few numbers, you can look down, refresh it, look up at me and read it that way. Is that okay, Judge?
Sure.
I have no objection to that procedure for listing the evidence tag number.
Thanks. Okay, what is that tag number?
For the crack cocaine?
Correct.
It's gonna be 2300 22154.002.
The findings of this firearm. When you found this firearm, did you relay that information to anyone?
Over dispatch, yes.
Who did you relay it to?
Dispatch.
Did you relay, when you found this firearm, were there any other officers you relayed that information to?
Not specifically, no.
Okay, but you did speak to Officer Reyna over the phone, correct?
Yes.
Okay, and what did you say to Officer Reyna specifically?
There was a firearm located in the trunk of the vehicle.
Okay. And Officer Reyna is the individual who took the defendant as a courtesy.
Your Honor, I'm just going to object to the form of the question.
Okay, yeah, no, it's already been answered. Nothing further for this one.
Counsel, your witness?
A few questions for you. So you stated that you located a gun in the trunk of the car that Mr. Knighton was driving. Is that correct?
Yes.
And you stated that this gun was wrapped in a t-shirt?
Yes.
And it was inside a bucket?
Yes.
Safe to say that this gun was not accessible from within the passenger compartment of the car?
No.
It was not visible from the passenger compartment of the car?
No.
And safe to say that even upon opening the trunk, this gun was not immediately visible?
No.
Now, once you pulled out this gun, it was not loaded with a magazine? No?
It was loaded with a magazine.
Okay, I would like to show you the footage of you removing the gun from the trunk.
Full house.
He's hard to keep track of.
I'm going to show him some.
No objection.
Your Honor, ma'am. If I can, before I play this, do you already recognize what this footage is?
Yes.
Is this your body worn camera from the date of December 7th, 2023, I believe?
Yes.
I'm going to play about 30 seconds of it, starting at 15:44. Now I've paused it here at 16:05. Do you now see what looks like a gun in your hands on your body cam?
Yes.
And did you see an orange bucket previously?
Yes.
And safe to say that you removed the gun from that orange bucket?
Yes.
Now, it may be easier for me to use stills from almost this exact same period of time. Or I can continue playing until 16:14, which is where my first still is from. Now I've paused it here at 16:13. Officer, do you see the bottom of the handle of that gun?
Yes.
And you would agree it appears that there is a hollow space at the bottom there?
Yes.
And you would agree that no magazine appears visible in this picture?
Yes.
And this picture depicts just about 20 seconds after you removed the gun from the trunk, correct?
I can't recall the exact time.
Well, we did just watch the video, right? That
Yes.
showed you removing the gun from the trunk.
Oh, some of this stuff.
We did just watch the video showing you removing the gun from the trunk.
No.
We didn't just watch that?
No.
What did we just watch?
It was me going through a bucket and me retrieving the firearm from the top of the vehicle.
From the top of the vehicle?
Yes.
Oh, okay. So that was not you removing it from the trunk?
No.
So when had you removed it from the trunk?
I can't recall exactly. It was before that video that you just showed.
And so would your testimony be that there was, let me ask this. Does this gun look in this video like it did at the time when you did remove it?
No.
Let's cut to the chase. Did you remove the mag after you found the pistol?
I did, yes.
There you go.
Now, Your Honor, I would like to approach you with a copy of the report. I can do that on my computer. However, Mr. Muhammad, I believe you have a printed copy. Thank you. Ma'am.
Yeah.
This is a copy of your report from this incident, correct, Officer?
Yes.
And it lists 3 pieces of evidence that were seized. Is that right?
Yes.
And one of them is the Sig-Sauer pistol.
Yes.
The other is the crack cocaine.
Yes.
And the other is the marijuana.
Yes.
Now, there's no separate listing of evidence for ammunition, is there?
No.
And the description of the pistol does not contain any description of ammunition, does it?
No.
It doesn't specify that there was a magazine, does it?
No.
And there's no point in your report in which you indicate that you removed a magazine from the pistol, is there?
That is incorrect. There is.
There is a point. Could you identify that for us?
Yes, it's under inventory search.
And if I may. I see where you say the handgun was cleared and made safe, no round in the chamber. Is that what you're referring to?
Yes.
Safe to say that you don't use the word magazine in that statement?
No.
You don't use the word ammunition in that statement?
No.
And there's no specification anywhere in your report of how many rounds might have been in this gun?
I can't recall.
May I approach again?
Sure.
Can you confirm that there's no indication anywhere in the report of how many rounds might have been found in that gun?
I don't believe this is my full report, sir.
All right. Well, then I'll have to use my computer. Pardon the delay, but I do have your full report on my computer, and I just want to make sure that the record is clear about what you're report does and does not contain. Officer Paquette. Romulus Police Department case report, scrolling down to this last page.
Mhm.
Do you believe what we just viewed is the full extent of your report?
Yes.
And Officer Paquette, can you find anywhere in there that indicates the number of rounds that you claim were found in the gun?
No, there's not.
Okay. I have nothing further.
Mr. Mohammed.
Officer Paquette, you did make this weapon, this firearm safe, correct?
Yes.
How did you do that?
I removed this magazine from the gun, and then I racked the slide back to ensure there was no bullet in the chamber.
Okay, now this magazine, did you personally observe bullets in that magazine?
Yes.
Okay. And that firearm that we saw in that video that defense counsel showed, that was out of frame for a little bit. At some point, it was on top of the vehicle you mentioned?
Yes.
Okay. Nothing further.
Any recross?
Very briefly.
Go ahead.
So so you're saying you cleared bullets out of a magazine?
No.
Now, what did you do?
I removed the magazine from the gun.
Okay. So you didn't remove bullets from the magazine?
No.
But then you have the magazine and the gun as two separate items.
Yes.
But the magazine is not listed separately as an item of evidence in your report, correct?
No.
Correct?
Yes, correct.
Thank you. No.
Okay. Officer Paquette, you can step down. Watch your step on the right. Can we let him get back to his regular duties?
Yes.
Okay. Stay safe. Anything else from the people?
Yeah, Judge, people will follow this very, very briefly. Officer Reyna. Let's see.
Is he out there somewhere?
Yes.
Raina here? Officer Raina, come on up. Yep.
Typically, we would have Mr. Mohammed hold that report and refresh your recollection if necessary.
Raise your right hand. Swear firm, tell the truth, all the truth, nothing but the truth. Have a seat right here. Settle in. When you're ready, Mr. Mohammed.
Thank you. Good afternoon, Officer Reyna. Can you please restate your name for the record?
Chris Reyna, R-E-Y-N-A.
Okay, Officer Reyna, are you currently employed?
I am.
And who is your employer?
Romulus Police Department.
And in what capacity?
I'm a police officer.
And were you employed in this capacity as a police officer on December 7th, 2023?
I was.
And did you work this date?
I did.
And did you work this date by yourself or with a partner?
With a partner.
And what is the name of your partner or partners?
Be Officer Christian Otter.
Okay.
He was on FTO that day.
On this day, did you work in full uniform or modified uniform?
Full.
Were you on foot patrol or in a scout vehicle?
Scout.
Did your duties on this day of December 7th, 2023 take you at or near the location of Merriman and Flynn?
It did.
Is that located in the city of Romulus?
It is.
County of Wayne?
Yes.
And what took you to that location on that day?
Officer Cat had made a traffic stop.
Okay.
So,
So why did you go there though?
to be honest with you, I don't recall if he asked for backup specifically, but it's just common practice in our police department that anybody initiates a traffic stop, you just go as a different officer and go back them up just in case the scene gets fluid.
Okay. And what did you do when you made that location?
I was asked to.
Your Honor, I would object to testimony about what he was asked. I would ask that Officer Reyna limit his answers to his observation and his statements.
Fair enough.
What did you do?
I conducted a courtesy ride.
Okay. And who did you give a courtesy ride to?
Mr. Knighton.
Okay. Do you see Mr. Knighton in the courtrum today?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
He's wearing a blue suit jacket.
Noted.
Thank you. And did you give a courtesy ride?
I did.
Okay. And did anything happen during or after that ride?
Yes.
What occurred?
We made an arrest.
Why did you make an arrest?
Was advised that he had a firearm in the vehicle. Further investigation showed that he had a prior felony within, I believe it was 3 years on a CCH, so we had felony in possession of a firearm.
Okay. And what else during that arrest, did you learn anything?
Yeah, so we originally searched him, didn't locate anything with evidentiary value. At some point while he was in handcuffs, he advised us that he had narcotics on his person.
Did he say what kind of narcotics?
I believe he said, I don't want to specifically, don't remember the exact terms, but he advised he had narcotics.
If Officer Reyna doesn't remember Mr. Knighton's statement, then I would ask that he not speculate as to what he might.
Fair enough.
I don't recall the specific term that he may have used for a specific narcotic because numerous street names are used. But I know he advised that he had marijuana on his person and crack cocaine on his person.
Okay. Nothing further from this one.
Any cross?
Just very briefly.
Yes, sir.
You never saw this gun that was supposedly taken out of his trunk?
On scene? No,
Yeah.
sir.
You never saw on the scene any ammunition?
That is correct.
Correct, you never saw it.
That is correct, sir.
All right, nothing.
Any follow-up?
Nothing further from this one.
Can we send Officer Reyna back to duties?
Yes, Judge.
Be safe, Chris.
Judge.
Anything else from the people?
No further witnesses.
Any witnesses from the defense?
None.
I'm ready for argument.
Judge, the people moved for a bind over on all counts. I understand based off, defense counsel's questions and stuff, that there's an issue potentially in regards to the ammunition. The testimony today by the officer was that he personally observed the weapon that he made safe contained bullets. I believe that's enough for this case to be bound over. I believe at the very least, there's a question of fact. There was reasonable suspicion to approach this vehicle and make the stop, and that was the defendant running a red light. That's a ticketable offense. Upon that stop, Officer Kett discovered that the defendant had a suspended driver's license. He issued him a citation. He let him go. Oh, go ahead.
You're doing it again.
What's that?
You're recapping everything I just went through.
Oh, yeah. So, Judge, at this time.
Reserve argument.
Yeah, I reserve argument.
Judge, we're objecting specifically to bind over on counts 2 and 5. That would be the felon in possession of ammunition and the accompanying felony firearm. We heard no testimony that could credibly make the case that ammunition was recovered and collected in this case. We have an officer seeing his search of the trunk and saying, oh no, I removed the gun previously. We have an officer saying that he separated a gun and the magazine that was not visible in the footage that we saw. Yet, having ostensibly two different items, he doesn't list these items as different pieces of evidence. I mean, we've got two whole felony charges against Mr. Knighton based on the existence of bullets that are not even listed as evidence. All we have is the statement that there was a gun. No specification of whether there was a magazine, no specification of whether there were bullets inside. And the way that Officer Paquette read from his report, it's described as the handgun was cleared and made safe, no round in the chamber. He couldn't find any mention in his report of any specific bullets or specific number of bullets. I mean, how do you try to make out charges like this without specifying the physical object that the charge is supposed to be connected to? I mean, I'm not objecting to the other counts, but I do not believe that Mr. Knighton should be bound over on counts 2 or 5.
Thank you.
Judge, the testimony today by the officer was that he personally observed not only the ammo, the magazine, but bullets inside of that. As you could see from the video that was introduced by defense, the gun was out of frame for a little bit. It wasn't fully in frame. So I think it's a question of fact. I don't see any reason why the police officer, would potentially, hold back on that or lie. I think it's truly just a question of fact. I believe the officer testified to his observations, and I believe that's enough to have this case bound over to circuit court on all charges, because I think that's a question of fact for the entire fact.
I agree.
Thank you.
I think the officer's testimony is enough to get it downtown. AOI date is going to be the 27th of March, 9 a.m. Bond will be continued unless I hear something different real quick. Hearing nothing. Good luck downtown, sir.
Thank you, Judge.
What's next? What are we doing on Kazoo?
Judge, the parties are in mutual agreement for 1 week adjournment to try to get a plea. We're this close.
Okay, done.
An adjournment for a PCC or another thing?
Yeah.
It's resolving.
If
Then it'll be a PCC.
either I'll set it for a PCC in 1 week and you can resolve it there, or I'm going to set it for an exam my next docket. Because I don't dump exams on my bench.
Yeah, I think that this case is resolving.
Okay, go ahead and put your appearances on.
Good afternoon, Your Honor. Aaron Jan, for the people, P78733. Judge, she's in custody. Would you like?
It's up to you. You want her in, or you want to waive her presence?
I can waive her up here and talk about her.
Okay.
In Neighborhood Defender Service by Lauren Anderson. She is in custody. I would ask waiver of presence.
Done.
Judge, as the court's aware, today's big time set for the preliminary examination. This is a unique case. Case it in our elder abuse unit. The victim in this case is an elderly man in a wheelchair.
Yep.
His daughter is the defendant. I know that previously she was not confident to stand trial and is now confident. Today, obviously, can't. Again, this case has a unique posture because of where it's at, especially victim unit, the relationship between the victim and the defendant, and kind of the evidence in the case, and perhaps most importantly, the defendant's mental health struggles. The prosecutor's office, in conjunction, I spoke to my supervisor. She's charged with assault with intent to murder, and the complaining witness in this case does not, at least it's our understanding, does not want to cooperate today. The officer in charge did send a car over to the house. They were served and knocked at the door, and no one's entered the door. Now, the people do have some concerns about ongoing safety.
Sure.
Because of this complaining witness, his fragile age and disposition, and the defendant's mental health struggles, and the facts of this case. It's my understanding the police went over there 20 to 30 times. There's been 20 to 30 calls to this house for various issues surrounding the defendant. All that said, we are trying to capture a plea in this case that serves both the defendant and ensures protection of the victim, the captures of mental health struggles, and so on and so forth. And Ms. Anderson, I know that she's represented my office and been in contact endlessly with various institutions in the state of Michigan, even in the state of Ohio, to try to get Ms. Kazoo some help. So the people are prepared, at least at this stage, to extend an offer of aggravated domestic violence 1 year
Right.
misdemeanor. With agreement of 2 years of probation, she'd be tethered
Yep.
to a treatment facility.
Yep.
And that tether component is very important. And I think that there would be any substantive violation which would potentially result in some sort of jail time. That said, I will give the final offer to Ms. Anderson. There would be a psychological evaluation. She'd have to follow any recommended treatment by that psychologist. Any, additional terms and conditions this court imposes after reviewing the file and recommendations by the probation department. That was actually why I was talking to that probation agent.
Sure.
To ensure that we have the proper language. So respectfully, Your Honor, all of that said, we're asking for just a brief 1-week adjournment.
Done.
Get those final languages in place. And I think that Ms. Kazoo potentially avails herself of that offer.
All right, good luck.
Thank you, Judge.
I'm ready on Conley.
Ready.
Ms. Bashan, good to see you as always.
Right back at you, Judge.
Put your appearance on the record if you would.
People asking permission to practice under the supervision of APA Mohammed P86771, NPR 821.
Granted.
And good morning or afternoon, Your Honor. Kim Bashan, Neighborhood Defender Services, P59167. It's my privilege to represent Ms. Conley. It's my understanding people are ready to proceed. Ms. Conley and I have had a lovely conversation regarding the nature of a preliminary examination, in that the people who need to prove by probable cause a crime has been committed. She may be involved in that matter. After that discussion, she's indicated she wants to free and voluntarily waive that right. Understanding she'll be bound with the circuit court on the charges in the complaint and the warrant, and we will be applying for the diversion program.
Good luck.
Thank you, sir.
Ms. Conley, true, you're waiving the exam?
Yes.
You understand your rights and options?
Yes.
You understand the reason for the exam?
Yes.
What the people would have to prove at the exam? Yes. And you understand what happens when there's a waiver? Any questions?
Yes. I'm sorry.
Any questions?
No, sir.
Ladies, satisfied?
Satisfied, Judge.
All right, I need signatures. AOI is next, 2 weeks out on the 27th.
And Judge, just for the record, this is.
Who are you?
Mohammed, for the record.
What, you didn't think she could handle it?
I just.
I'll clarify, we haven't offered diversion, she is seeking it.
Yes, we're just applying for diversion.
Understood, understood. Mohammed, you can't delegate and then just take it right back.
May we approach for those signatures, Judge?
Please. Ms. Conley, good luck downtown, man. Are we ready on Turner?
Yes. I should be yours.
Judge, can I just check the witness?
Yeah.
Thank you, Judge. A lovely day to you and your staff as always.
Thank you very much.
Good luck. I'll trouble meeting the boss.
Oh, let me go get I'm gonna turn off the PTR for you guys.
They're not listening to you, Heather. Are we holding, counselor?
We are, we're ready.
Come on up and have a seat.
How you doing?
Better than I deserve, Mr. Turner. Is Turner yours? Okay.
No, yeah, your close up, your minute, send her back.
He likes to wait to prep his exams until they're called.
Jake. I want a pistol. Yeah.
My nose.
And it's a Chinese, rubbing up against her legs, it just came into her yard. Well,
That was my first time being in the course. Hopefully it lasts.
Hopefully. So we're like trying to get an appointment.
Yeah.
Hello.
Are we ready on Turner?
Yes.
Appearances.
Mohammed, good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Good afternoon, Your Honor.
You
Sophia Nelson, Neighborhood Defender Service, on behalf of Mr. Turner, P77960. Mr. Turner is with me in court today. Mr. Turner, can you state your name for the record?
Lydell Turner.
Thank you.
Judge, pursuant to, the people would like to request a mutual order of sequestration. I know there's no one here, but just had it.
Done.
And the people would like to call Prince Robinson to stand.
Ready.
Do you want me to go call?
Please.
If I need to play body worn cameras, the best way to do that is to join the Zoom.
Probably. You could try it with the, what do you call it thing?
HDMI.
So you could try it with you could try it that way.
It's usually better with the HDMI.
Robinson up front.
And Judge, in regards to my mutual order of sequestration, I'd like to request an exception to the officer in charge, which is Detective Bryce, who's walking in right now.
Your Honor, I believe this young lady is a potential. Okay.
No objection to Rice though.
No.
All right, Robinson up front. Raise your right hand for me. Swear affirm, tell the truth, the whole truth, nothing but the truth today?
Yes,
All right, you're gonna sit right over here, watch your step on this ramp. Settle in that chair.
Okay.
When you're ready, Mr. Muhammad.
Good afternoon, Mr. Robinson. Can you please restate your name for the record?
Prince Robinson.
All right, Mr. Robinson, I'm going to take you back to the date of January 10th, 2024. Were you at or near the location of 9460 Biddle Avenue?
Yes, sir.
Apartment 791?
Correct.
Is that located in the city of Romulus?
Yes, it is.
County of Wayne?
Correct.
What's at that location?
My clothes, my property, where
Okay.
I stayed at.
And were you at that location on January 10th, 2024?
Yes, I was.
And did something occur at that location on that date that brings you into court today?
Yes, it did.
What happened?
An argument. Our argument broke out.
I'm sorry, what was that?
I said the argument broke out.
Okay.
You want me to tell you why the argument started?
Well, who is this argument with?
My brother, Lydell Nathaniel Turner.
Okay, do you see your brother in the courtroom today?
Yes, I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
Yeah, him right there with the braids, with the Nike jacket on.
Noted.
Thanks. Okay, and what happened during that argument?
Basically during that argument, I was there to try to get my belongings. And as I was trying to get them, he was trying to rush me and get at me. In the midst of that, he threw to
I'm sorry, you said he was trying to what?
rush me, like come towards me, get at me,
Okay.
you know, like put his hands on me physically. So he couldn't do that. So he went and grabbed 2 wine bottles.
Okay, why couldn't he do that? Were you moving away from him? What was-
Objection leading.
Why couldn't he get to you?
Apparently he couldn't get past his girlfriend, Ashley Davis.
Okay. And then you mentioned that he had grabbed some bottles?
Correct, 2 wine bottles.
Okay, and did you observe what he did with those wine bottles?
Yes, he threw them right at me.
Okay, where is it at you? Like, was it
Like,
at your
right at my
face,
body.
At your, where on your body?
Like towards the stomach way. As he threw them, as they was coming my way, they came directly in my direction, hit me in the lower torso.
Okay, so did they both make contact with you?
Correct, they did.
When he picked up that first bottle to throw it at you, how did it make you feel?
Bad, very threatening.
Objection relevance.
It's an element of the crime showing that how he felt when he felt threatened when the bottle's coming at him. How is that not relevant?
It's relevant. Go ahead.
So when this bottle was coming at you, how did you feel?
Very bad, threatening. It came from my own brother, family.
Okay. Did both bottles make contact with
Yes,
you?
they did.
Did you sustain any injuries?
No, I didn't.
What did you do afterwards?
After the bottles were thrown?
Did you call the police?
I called the police, yes, I did.
Why did you call the police?
Because I was feeling threatened.
And your brother's the individual who threw those bottles at you, correct?
Correct, yes, sir.
All right, nothing further for this one.
Cross exam.
So I am connected and I will likely have to play at some point.
Okay.
Do you mind if I ask questions from here? Just
No, go ahead.
Just play the microphone.
As long as she's keeping you up, you're all right.
Got it. Mr. Robinson, your brother called you while you were at work, is that correct?
Correct,
And you were upset because he was throwing all of your stuff out of his apartment?
correct,
And when you arrived at the apartment, all of your stuff was in the front yard, correct?
correct,
And you were angry?
correct. Wouldn't you be?
What?
Correct, wouldn't you be?
So I ask questions and you answer them. It's not your turn to ask questions. Can we not share my questions? There we go. And where were you when Mr. Turner allegedly threw these bottles at you?
Standing in the doorway.
Okay. And where was Mr. Turner?
In the hallway.
And this bottle that was thrown at you, it wasn't broken, correct?
No, it wasn't.
Objection, relevance.
It goes to whether or not it was a dangerous weapon.
Yeah, that's relevant.
And where in your body did the first bottle hit you?
Like in the stomach area.
And what about the second bottle?
Towards the leg.
And when you saw your belongings on the front yard, you began banging on the door and banging on the window to his apartment, correct?
No, I had a key. So there was no need for me to bang on the windows.
You wanted to fight?
No, I just wanted my belongings.
Your belongings were in the front yard.
It was more inside the house.
And when the police arrived, you were handcuffed?
You said when they arrived?
Yes.
No,
You were handcuffed because you were trying to attack a woman. You were in the process of attacking his wife when the police arrived?
Objection, assuming that's not an evidence.
It's a question, you can deny it.
Yeah, it wasn't phrased as a question though. Rephrase.
You correct that you were in the process of attacking Mr. Turner's wife when the police arrived?
No,
Okay, so the police didn't handcuff you and separate you from Mr. Turner's wife?
yeah, they handcuffed me, but it was never to attack anyone.
Okay. So earlier, when you denied that they handcuffed you, that was a lie?
Say it again.
Said earlier, when you denied that you were placed in handcuffs when the police arrived, that was a
Well,
false
that's not what he
statement.
denied. Your question was he in handcuffs when the cops got there? And he said no,
All right.
which technically is correct.
I'm looking to play. So it's your testimony that you weren't involved in a physical altercation when the police arrived?
Say that one more time here.
It's your testimony today that you were not involved in a physical altercation when the police arrived on the scene?
I'm gonna object.
What's your
It
objection?
wasn't an altercation. His brother threw 2 boxes.
You were not involved in a physical altercation with a woman when the police arrived on the scene?
Objection relevance.
It goes to his credibility.
I'll allow the question. Were you involved with a?
Again, no.
Okay.
Okay, I'm playing for impeachment. You want me to? That's very loud.
Yes, it is.
I will turn it down.
There you go. Good job.
Do you recognize this as the apartment complex?
Is that a yes?
Yes.
I'm gonna object. There's no foundation that's been laid.
Do you recognize this as the apartment complex?
Yes, ma'am.
Okay, and he will recognize himself in the video once that becomes apparent.
I understand, but this isn't his video.
I understand that it isn't his video, but it's impeachment. He just denied that something happened and this captures the entire scene. It's also discovery that you turned over.
It doesn't matter.
Do you want me to call
So is it a lack,
Probably,
is there a lack of foundation here?
Yes, lack of foundation.
Do you recognize this as the apartment complex you were at?
Yes.
If you let me play for a few more seconds, you'll recognize his voice.
I'll allow it. In the interest of saving time.
Is that you?
Yes, it is.
And was that Mr. Turner's wife that you were engaged in physical altercation with upon your arrest?
I'm gonna object. That's not shown in the video.
There's a woman right there.
I don't see
Replay
an
it.
altercation.
That was behind. Let me.
Sir.
When I object, you can't speak.
Go ahead.
There's no altercation in the video. Again, defense is assuming facts that aren't in the evidence.
I'm asking a question, and I think if you watch the video closely,
Go ahead and play the video again. That's enough.
Isn't it true that you were engaged in a physical altercation with Mr. Turner's wife when the police arrived, and that's why you were placed in handcuffs?
I'm gonna object.
What's your objection?
She's assuming facts not in evidence. There's
I'm
nothing-
asking a question.
Well, no, your question clearly assumes that there was an altercation, which has not yet been established. So, sir, was that you in the white shirt?
Yes, sir.
Okay. Was there somebody else right there on the porch with you as the officers ran up?
Yes, my girlfriend.
Anybody else on the porch?
No, sir. My fiance.
Sir?
Oh,
The
Pick
woman
up.
that was in the video is white, correct?
yes. Oh, sorry.
The woman in the video is white, correct?
Objection relevance.
It goes to his credibility.
It goes to his credibility.
The woman that was on the porch with you when the police arrived is white.
Yes or no?
Play the video for you?
I already know what's in the video. She was never on the porch. She was on the other. She was on the side. She was on the other side of the door.
So are you disagreeing that the woman's arm in this video is the arm of a white woman?
That's the arm of a white woman.
Okay, and
That was
Mr.
on the
Turner,
that was on the other side of the door. When the police came, the door was closed. Play the video again, ma'am. Play your video again.
yes, please.
Please.
You got issues? All displays.
just, so we're all clear, your girlfriend is African American, correct?
Correct.
And Mr. Turner's wife is white.
Correct.
So it appears to me that there are two women on the porch, your girlfriend and Mr. Turner's wife. Is that, you're denying that?
I'm objecting, I did not.
It's a question. It's a question.
He can answer the question.
Are you denying that?
Yes, I am.
Okay. Now, I'll look back and forth. When police arrived on the scene, they questioned you, correct?
Correct.
And you answered their questions?
Yes, I did.
And you answered them truthfully?
Yes, I did.
And you told them that you did not get hit?
I did.
You told them that you did not get hit?
I told him I did get hit with 2 wine bottles again.
And you told them that it was a scuffle?
Did I? Not that I remember.
Would watching your body worn camera or your statements to police refresh your recollection?
Say that again.
Would watching your statements to the police officers refresh your recollection of what you told them?
They can. I don't remember telling them it was a scuffle.
At this time, I will be playing from 4 minutes and 4 seconds to 4 minutes and 12 seconds.
Thank you.
So you did tell police that there was no assault and no one hit you?
Never said assault.
So there was a scuffle.
Well, replay that.
It's the difference between putting their hand on somebody and throwing 2 wine bottles.
So you told police there was no assault, correct?
Say it again.
You told police there was no assault
Yeah.
and that nobody put their hands on you
Yeah.
and that you did not get injured.
Correct. Never got injured.
And you didn't bring up anything about a bottle when you were interviewed by the police.
But I told them it was. So this was before I got in the car. I was talked to inside the car and outside the car, man.
So in fact, no, but you did not tell the police about any bottle, correct?
I'm gonna object, he just answered the question. He said he did tell them he was hit
He
by a
did.
bottle.
The police had to come to you and ask about a bottle before you said anything about a bottle, isn't that correct?
Not that I remember. They seen the wine bottles they seen the wine bottles on the ground that was thrown and broken as they was thrown at me.
The police asked you to give a written statement, correct?
Correct, and I don't think I did, right?
You refused, in fact.
Right, that's what I just said.
So when the police arrived on the scene, they asked you to do a written statement and you refused to do so.
Yeah, because I told them verbally.
And when they asked you what happened, you told them that you weren't assaulted and that no one laid hands on you and that you weren't injured, correct?
Objection, that's not, that's misrepresenting the facts. He did say he was assaulted, told police officers that he was struck by a bottle.
I'm asking about in the first instance, the police arrived and they placed you in handcuffs, correct?
Well, then I'm gonna object to lack of specificity.
Well, then I'm gonna re-ask the question.
Thank you.
So you are placed into handcuffs and put in the back of a police cruiser, correct? And you're asked initial questions about what happened. And you're told there was no, you told them there was no assault, correct?
Mhm.
And that no one laid their hands on you, correct?
Mhm.
And that you
Hold
were
on,
not,
hold on, hold on. Don't,
I'm sorry.
yes or no?
Yes,
and that you were not injured.
correct.
And then they came back to you and asked if there was a wine bottle, correct?
If they did, I'm not sure.
So that's the first time you mentioned anything about a wine bottle, correct? When they asked you directly about it.
I'm not sure.
Okay. And you told them there was one single wine bottle, not two.
Not sure. I definitely told them to.
So it's your testimony today that there were, that you told police that there were two wine bottles, not one. I'm asking you a question.
Yes, I said it was 2.
And again, when these alleged wine bottles were thrown, they were fully intact.
Yeah.
There are no jagged edges.
No, ma'am.
And it would be like if I threw my phone at you right now.
Right, basically, yeah.
Hit your stomach and bounce to the floor. That's what would happen if I threw my phone at you right now. It would hit you and then it would bounce to the floor.
Objection, speculation.
Yeah, I don't know where this is going, because a wine bottle is not a phone.
It's a similar size. They weigh about the same.
No.
No, again, that's objection.
The wine bottle didn't have any liquid, right?
Objection relevance. Whether it has liquid or it doesn't.
Well,
relevant.
it would make it a lot heavier if it was full.
It was an empty bottle, correct?
No, full bottle.
Full bottle. And so there would be wine everywhere in the hallway. You're telling me the full bottle of wine got thrown at you and it shattered, and there, what happens when a full bottle of wine hits the ground and shatters?
Objection.
It goes to credibility.
So what you're trying to get out of me is it would be water, technically wine on the ground, right?
Yes.
So the bottles was again, remember when I said I was standing inside the door? So the bottles went outside. So they didn't go in the hallway. As I was coming in, the bottles was getting thrown. So the bottles went outside. That's where the glass was at. When the police pulled up, it was outside, not inside the hallway, ma'am.
Okay. So full bottles of wine got thrown at you.
Correct.
To the ground,
Correct.
and the wine went everywhere.
Yeah.
On the sidewalk, was it red or white wine?
I'm not sure.
So it's your testimony that there would be pools of wine outside of the apartment complex.
Right. And at that time it was.
Okay.
Broken bottles and all, 2 of them.
All right, no further questions.
Thank you.
Actually, Your Honor, can I play the body worn camera to have him point out where these pools of wine are?
Sure. I don't know if he'll be able to tell by the video, but.
It's a well-lit front area of the apartment complex. I mean, Mr. Muhammad has a duty to put on testimony that's truthful, and he knows, based on the discovery, that everything this witness has just said is a lie.
You made your record.
Absolutely making a misrepresentation.
She can make her record.
How do I know that?
Have you watched the body worn camera?
Okay,
Do you know what
we're
the
not
other
gonna do
witnesses
this.
said?
People, we're not gonna do this. If you two can't play well together, leave it outside my courtroom.
It's not me. She's the one making these false accusations.
They're not false.
And if I gotta say anything to the two of you again, you'll both be held in contempt. I'm not gonna play it.
I'm gonna try to pull up the correct section, Your Honor.
Just for the record, I'm gonna stipulate to any videos from that day to be admitted into evidence today.
Thank you.
Does that mean I get to play his girlfriend's statement?
I'll stipulate to any videos that were produced by the prosecutor's office, the defense counsel, to be admitted and played today in court.
The apartment, location here, inside the story.
I know this guy goes back to the apartment. I'm just not sure exactly when.
And respectfully, Judge, just for the record, I just want to make sure it's been noted that what the defense counsel stated about me knowing any information is false is a complete and utter lie and misrepresentation.
Okay, I got it. I got it.
Sorry, I assume that prosecutors review discovery prior to exams, but I know in practice they usually don't.
Okay. And one more snarky comment from either of you, and we're gonna have a problem. Act like professionals.
All right, so this is the area you're speaking of.
Correct. You can tell it's wet right there.
I can tell it's wet, but I don't see any broken glass. You?
I mean, I can't see it from the video. I can tell you if I was there at that time of the day.
I see a bunch of.
It's very hard to see a glass on a video.
That door the cop just walked in, that's the door that you were
Yes, sir.
standing in, the wine bottles
Yes,
went
sir.
outside.
Yes, sir.
Thank you.
At this time, I have no further questions for this witness, but I would like the opportunity to play the statements of his girlfriend with respect to these wine bottles.
Were those videos that were provided by the defense?
They were provided by the prosecution to the defense.
Or that's what I meant, thank you. You can step down. Oh, any more direct?
Yes, Judge.
Go ahead.
As you saw in that video that was produced by defense counsel, there was wine all over the front door steps, correct?
Yes, sir.
Okay. And that's from the bottles that were thrown at you by the defendant. Is that
Yes, sir.
correct?
Yes, sir.
Is that your testimony today?
Yes, sir. Yes, it is.
And those bottles that were thrown at you, did they shatter? Do you observe them be shattered?
Yes, they did.
They were shattered?
Yes.
You observed that personally?
Yes, I did.
On this day of January 10th, 2024, were you arrested?
Yes, I was.
You were arrested and taken downtown or taken to the station?
No, I wasn't.
So you were not arrested?
I was just a handcuff.
You were detained?
Correct.
While the
Sorry,
police formed an investigation to find out what happened?
Absolutely, yeah. I wasn't, yeah.
And once the police made that determination, they decided to arrest the defendant and not take you down?
Correct,
to the
yeah.
station.
I was just detained. They took him to,
They did their investigation, they found out what happened, and then they made an arrest?
they took him down to the precinct from what I was noticing. Yes, sir.
Okay.
I was let go and able
There's
to
no
get the rest of
question on
my
the floor. No
Thank
question
you.
on the floor.
Nothing further.
Any recross?
No.
Okay, so you can step down.
Thank you.
Watch your step on my ramp.
Got it.
You can wait outside. You don't have to go outside, just outside the courtroom. Go ahead, Ms. Muhammad.
Judge, the people move for a bind over on count one.
I am going to.
Dangerous weapon. Oh, do you do that?
She wants to play her videos.
You said I could.
Yeah, I guess. Is the defendant here?
It's gonna be on yeah.
Video dial button or all displays?
All right, Your Honor, I'll play from 6:10. This is body worn camera of Officer Jacob Phelps. I'm actually gonna play from 6:20. I'd like the record to reflect that she said there were 2 bottles thrown, one hit her in the ankle and the other one didn't hit us. And he didn't hit her or Mr. Turner.
Any comment about what she wants the record to reflect?
The record reflects that testimony by this person. What appears to me is that the defendant bottles or a bottle. I couldn't hear.
I couldn't hear a thing she said, so.
I did hear throw bottles. Bottle, I couldn't tell.
I'm gonna replay. I'll turn it up.
What's the name of this individual?
This is Tatiana. She's in the hallway, I believe. This is your complainant's girlfriend.
At this point, I'm just asking about the stand.
Okay. If you want to call her.
It's your turn.
You said I could play videos. I'm playing a video. If you want to call another witness.
So I'm saying to understand exactly what said, if we can't, me and the judge both.
Well, give it another shot to hear. I'm turning up the volume. So what I got.
So what I just heard is he threw another bottle after he threw the first one. So I just don't understand what.
I heard her say that one bottle was thrown and it hit her in the ankle, and then he threw another bottle and didn't hit us. That's what I heard.
So what I'm hearing is she's not a listed complainant in this case. She says he threw one bottle at me. It hit my ankle. He threw another bottle at us and it didn't hit anyone. I think that is directly contradictory to what Mr. Robinson just testified to on the stand.
Okay. Anything else from the defense?
No, Your Honor.
Ready for close argument?
Judge, the people move for a bind over on count 1, assault with dangerous weapon, and their reserve argument.
Thank you.
Your Honor, first of all, the jury instructions define dangerous weapon for felonious assault as a dangerous weapon is an object that is used in a way that is likely to cause serious physical injury or death. If you are to believe the complainant, he was struck by a bottle that was fully intact and then hit the ground and shattered. That I do not believe falls under the definition of a dangerous weapon. And I believe this is at most a misdemeanor assault and battery. I also think that and the reason I was trying to use the phone as an example is, dangerous weapons are things that can cause serious injury. And certainly if you broke a bottle and came at somebody and tried to stab them with it, that would meet the definition of a dangerous weapon. But just simply throwing a heavy object at a person is not likely to cause serious injury or death.
Tell that to Goliath.
Okay, so I think it depends on the weight of the object. Yes, if I had the force and strength to throw a 20-pound rock at someone's head, it definitely could be seen as a dangerous weapon. But if I threw a 3.5-pound object at Mr. Muhammad's chest right now, I don't think that causes or is likely to cause serious injury or death. I don't think it meets, if you can't speak right now, I don't think it meets the definition of a dangerous weapon. And I think this is a gross overcharge. I think we also have serious credibility problems with this witness. He initially told police that there was no assault and that nothing happened. And then he was reapproached and asked about a bottle because of what his girlfriend had told the police. And now he's saying he was struck by 2 bottles, which is different than his statements to police. However, they're directly contradicted by who, if they had properly charged this case, who should have been the complainant, the Miss Tatiana. She says she got struck in the foot by a single bottle, and then a second bottle was thrown that didn't hit anyone. So I have concerns about Mr. Robbins' credibility. This court, pursuant to People versus Anderson, has a duty to evaluate credibility. I think that this man, police show up, he's obviously irate, he says nothing happened. And then, after sitting in handcuffs for a while, I think he has some concerns that he might be in trouble for banging on the windows and all the other stuff that he did. So he fabricates this story about being struck by a bottle when we know from the other party that he was not struck by any bottle. 2 bottles were thrown, one hit her in the ankle and the other hit nobody. So I don't think the prosecution has proved each and every element of this offense by a probable cause standard, both when you consider that even if you take this witness at his word, I don't think a wine bottle qualifies as a dangerous weapon in the way that it was allegedly used in this instance. And because I don't find this witness credible, I think he has seriously credibility concerns. And this court, the reason we have these hearings is for judicial economy. And if we think for 1 second that a jury is going to convict Mr. Turner of assault with a dangerous weapon, I think that's really misguided.
Your turn.
Judge, the court doesn't have to find that that a jury's 100% going to find this individual guilty of a crime. They just have to have, there just has to be a question of that. And I think based on the testimony presented today by the witness, and even the video that we observed where we saw, what appeared to be wine all over the front porch, the testimony by the witness said that he felt in fear, he felt threatened when 2 bottles came in his direction that made contact with him. He observed that these bottles were shattered, so there must have been enough force to have used that weapon, which in this case is a glass bottle, that could cause serious injury. So the people move for a bind over. We believe that there's a question of fact for the trier of fact in regards to count 1, which is assault with a dangerous weapon. Thank you.
Thank you both. I certainly never would have approved this complaint on these facts. But whether or not the wine bottles as used that night were a dangerous weapon is an issue for the trier of fact. Had the complainant ducked and took one of those bottles in the head, we might have had a completely different story. The other thing I'm troubled with is your classification that he told the cops nothing happened. He didn't tell the cops much at all on video. He answered their questions. The officer said, so you weren't assaulted? No. Well, that gets to what he thinks is an assault. Nobody laid hands on you? No. What's that bloody lip you've got? Well, my brother tried to lay hands on me, but he didn't make it. So it's not like the cops said, what happened here? And he said, nothing, we're all cool. Just, we had words. It's a total spin on what I heard on the video that doesn't fit. This one is an extremely weak case, no doubt about it. but it's an issue for the trier of fact. There's enough for probable cause. I'm sending it down. AOI is going to be the 27th of March at 9 a.m. Bond will be continued. Mr. Turner, I wish you luck downtown. When did we get the call from Riggins? Do we know? Hey, did you guys hear from Attorney Riggins? Do me a favor, send Mr. Campbell in there. Thanks. Are you Mr. Campbell? Come on up. Mr. Campbell, your matter was set for 1 o'clock, correct? Have you had contact with your attorney?
I did. He said he was on his way. This was, and I guess whoever called, she called or whatever, and they said he was gonna have.
Did you talk to him too, counsel?
Yes, Judge.
So-
He indicated he was just leaving Frank Murphy.
When was that?
I believe about 1:30.
He called me back and said that he'd have one of his other attorneys standing in or something.
All right. Are you ready to go?
Judge, this will be a dismissal.
All right, well, I guess we'll wait for that. Okay, I just want to know where we're at. Just have a seat up in the hallway. Counsel, can we do that now?
I'm ready. We just need to.
Now, I don't need,
Okay.
if you're gonna nolly process, I don't need anybody. All right. So if you want, if you can get hold of your attorney, tell him to save, don't be doing 90 miles an hour and her case is dismissed.
Well, he said he had one of his attorneys here. I guess I don't know. They were supposed to be standing in or something. So
It doesn't matter. Case is dismissed. She doesn't want to move forward. It's done.
thank you. That's it.
You're all set.
Thank you, Judge.
You don't have any cash bond posted, correct?
No, sir.
You're good.
Thank you.
And I'll text Mr. Riggins and let him know.
That's nice. Thanks. Hey, Jamie, those are going down to Mackenzie when they can.
Is this our HDMI cable here?
Yeah, it was.
The judge?
Yes.
Joe Rock went down there, everything was gone off that truck.
Good.
The only thing they had
Good
on
for
the
him.
side, everything. They'll be back 20.
Good for them.
I'll have to try it next time you're here.
And don't wait till the end of the day.
Yeah. Well, you said the wing sold out really fast.
Good. What's that?
You said the wing sold out really fast, right?
Yeah. Well.
Now